the matter before SLC, Lordship. Page number 18 is the direction of this Honorable Court. Last para, Lordship. In view of above, pursuant to this direction, Lordship, my case was placed before SLC and they rejected, Lordship, without assigning any specific reason, Lordship. Page number 24, Lordship. Serial 79. Ground of rejection, Lordship, not within 5% quota. Challenging this SLC meeting, Lordship, SLC, we approach this Honorable Court, this instant writ petition. During the pendency of this writ petition, Lordship, they have filed an affidavit in opposition, Lordship, saying that they again placed my case in SLC dated 15/2/2022, Lordship. In that, page number 7, may kindly be seen, Lordship. In that SLC, my case was again rejected, saying that I am underqualified. I'm class 9 pass, Lordship. Page number 7 of their affidavit. Last page.
Yes.
Serial 14, Lordship, last. Underqualified, Lordship. As per their stand, Lordship, I'm 9 pass and I'm underqualified as I'm not 10th pass, Lordship. But Lordship, I have filed my reply, Lordship. In my reply, Lordship, I am vehemently opposing that because, Lordship, my qualification is 9 pass and this gadget came in the year 2021, Lordship. My father expired in the year 2014. DLC was much earlier, Lordship. It has come in the year 2021. Even then, again, the PWD department, last page of my affidavit, Lordship, page number 14, they advertise another post of grade 4, specifying the qualification as class 8, Lordship.
Where?
Page number 14, my affidavit, Lordship.
Your
Last page of my reply affidavit.
Page number
14, Lordship, Annexure B.
Yes.
Lordship, the 0.5, Lordship, qualification, 8 pass. Peon, Khalasi, Chaukidar, minimum qualification, 8 pass. The PWD department, Lordship. And recently, Lordship, our Honorable High Court also advertised a post of in the year 2024, Lordship, grade 4, specifying the qualification as class 8, Lordship.
But then are you not supposed to challenge this SLC minutes?
Lordship, they have, yes, that is their, Lordship, but I have already filed the reply.
You may have filed a reply,
Lordship.
but then this 15/2/2022, which says that you are underqualified.
Lordship.
Are you not supposed to challenge this?
That is their, Lordship. I will have
Unless
to.
unless you challenge that, what can we do?
Lordship, it is there, but this stand is not.
That stand we understand. We
Lordship.
understand that point. Now that they've made the advertisement saying it is 8 pass.
Lordship.
But then the SLC in its minutes on 15/2/2022
Lordship.
rejected your case on the ground of not being qualified.
Lordship.
That has been brought to your notice through the affidavit in opposition filed by the respondents.
Lordship.
Now, are you not supposed to challenge this?
Yes, Lordship, I will have to challenge that.
Then,
In that case, Lordship, liberty may be given to us to challenge this notification.
yes.
My lord, this is a very pertinent thing that again we have rejected. Even then, my lord, the thing is that I am on a different footing, my lord. Petitioner's father died in the year 2014. We are in 2024. 10 years has passed. Debabrata Tiwari is specifically, my lord, against this, my lord. If I may read, my lord, just 7.5 of the judgment passed by the Honorable Supreme Court. This is delay part, my lord, on both the on authorities and as well as on the petitioner. It deals with both the thing, my lord. Considering the second question referred to above in the first instance regarding whether application for compassionate appointment could be considered after a delay of several years, we are of the view that in a case where for reason of prolonged delay, either on the part of applicant in claiming compassionate appointment or the authorities in deciding such claim, the sense of immediacy is diluted and lost. Further, the financial circumstances of the family of the deceased may have changed for the better since the time of death of the government employee. In such circumstances, court or other relevant authorities are to be guided by the fact that for such prolonged period of delay, the family of the deceased was able to sustain themselves, most probably by availing gainful employment from some other source. Granting compassionate appointment in such a case, as noted by the court in Hakim Singh, would amount to treating a claim for compassionate appointment as though it were a matter of inheritance based on a line of succession, which is contrary to the Constitution. So now, my lord, here is the thing that there is a delay. We have decided, my lord, consider twice. First is 5% quota, meaning thereby that there was not 20 vacant posts. Out of 20 only we could have carved out one. There was not. First we have decided, my lord. Again, on the next, my lord, in 2022, again we have decided. So, my lord, in between, 10 years has passed. So, my lord has to look into this aspect again. Whether Debabrata Tiwari, my lord, this is the latest judgment of the Supreme Court, but they have laid down law.
But delay was not due to me, Lordship.
That is what
I applied on within time, Lordship.
Yeah, you have applied within time,
Lordship.
but then you have been able to sustain till now. So that part you will have to answer also.
Lordship.
Plus this minutes.
Lordship,
It's
I'll have
not
to
under
challenge
challenge.
this. Lordship.
So not, minutes is not under challenge. You have to explain how you have sustained
Lordship.
throughout this 10 years.
Lordship.
All these things you have to explain.
Lordship.
You
I will
have to sat-
challenge.
You have to satisfy this court.
Lordship, I'll challenge that minutes, Lordship.
It's up to you.
Lordship.
It's your choice.
Liberty may be given to us to
Yeah,
challenge this.
the learned additional senior government advocate
Lordship.
is on a different footing.
Lordship,
That
I have
is only
understood.
A delay of 10 years.
Yes, Lordship. Debabrata Tiwari, I have understood, Lordship.
So what do you want to do?
Lordship, liberty may be given to us to challenge this, the last rejection, Lordship, explaining the delay.
When was this counter filed?
It was filed on, I received on 19/5/2022 and reply I have given on 10/6/2022.
So 2022 itself, they filed your affidavit.
Lordship.
And if it did not occur to you that you have to challenge this also. Another 2 years have gone by.
another thing, my lord. Initially, we have rejected in 2018. She has come before this court in 22. There was a delay, adequate delay, my lord. Our first, that is in page number 20 of the writ petition, my lord. My lord will find the top 31/12/18.
That I've seen.
So, and the writ petition of 22, my lord. 4 years delay. That is also there, my lord. So it is not that, my lord, they are deciding the case. So already the Supreme Court is held, my lord.
I'm praying for Lordship, a liberty to challenge the next rejection, Lordship.
So what liberty?
In that case, Lordship may provide us some time. In the meantime, we will challenge this, no, rejection or rejection
See,
SLC.
this affidavit was filed in 2022
Lordship.
and it brought to your notice in the year 2022.
Yeah, I have understood, Lordship. But Lordship was trying
You
to,
got it?
yes, Lordship.
So in 2022 to 2024, you've done nothing.
No, we have filed our reply, Lordship.
You may have filed your reply, but then immediately you could have challenged. If you have immediately challenged it,
Lordship.
here also there's a delay of 2 years. First SLC also there's a delay of how many? 4 years.
4 years. 6 years one in between.
4 years. And in between now 10 years.
Lordship. 10 years they have placed, they didn't place my case,
Maybe,
Lordship.
maybe they did not place, maybe you have applied at the appropriate period of time.
That is what Supreme Court says, my lord.
That is a different issue.
Lordship.
Now the issue is, in 10 years, how have you been able to sustain yourself?
Lordship.
So the immediacy of completion of the appointment does not arise. So you don't have a good case. So we'll dispose of this matter.
And Lordship giving liberty to challenge the
No, no,
next.
no liberty. I'm dismissing your writ petition.
Lordship, in that case, 2 weeks time may be given. In the meantime, I will challenge the satisfying your Lordship the delay.
My lord, I have already brought before your lordship.
That I've seen.
That
My lord.
I also know, Lordship Devabrata Tiwari.
It says that both, my lord, on the part of the petitioner or the authority.
Yes, I
decide.
know that.
Give a hard copy.
My lord, I'll just get that.
In the
7.5.
meantime, I will challenge Lordship, satisfying the delay,
So
Lordship.
what do you want to do?
Today,
Dis-
2 weeks time may be given to us.
Dispose of.
No, Lordship. 2 weeks time may be given to us. In the meantime, we will challenge, then Lordship may consider.
Till then, there'll be no point. There's no point.
I'm leaving up to your Lordship.
Till then, there'll be no point.
Lordship.
You have a bad case.
2 weeks time may be given to us.
Okay, on request made by us, Kanunul and council, the petitioner list the matter to 2 weeks.
So,
judgment of the Sabha
Yes.
made to the lordship. In this case, the petitioner with your lordship was initially appointed as computer operator, my lord.
Hmm.
On 1/1/2009.
Hmm.
Since 1/1, also will find the appointment order at page 39.
Yes.
In the interest of public service, Raju Bhuya is hereby temporarily appointed as computer operator for the smooth functioning of the division until further order. This is the initial appointment, my lord. Thereafter, my lord, they have certified that I was continuously working. My lord, page 18, lordship will find
Page
18, my lord.
18.
18, my lord, 1/8. 1/8.
Yes.
My lord, this was certificate issued on my lord 29/7/2010. It says that my lord, with January 2009, till that day, I was continuously working.
Your appointment order is 1/1/2009.
Yes, my lord.
Yeah. Then,
This is the first certificate they have issued. Then my lord, also annexure 2, page 19, my lord. This was issued on my lord 27/2012. Certifying my continuance, my lord.
Hmm.
These are the experience certificates also will find up to page 25. No, my lord, up to page 23. These are the experience certificates, my lord, they have issued time and again. That I was continuously working. Then, my lord, page 26, annexure 9. The
Hmm.
executive engineer forwarded my a proposal to the chief engineer for my regular absorption against the vacant post.
Your appointment was against a substantive post.
No, my. Initially, it was not substantive
There was
post,
no
my lord,
post.
due to need of the office, my lord, they have appointed me.
Hmm.
My lord, I am not praying for regulation of my service, my lord, at
Hmm.
this stage, my lord. I am praying only for the salaries for the period for which, my lord, I have rendered my service, my lord. So, my lord, page 28, loss will find. This is another proposal to the chief engineer by the executive engineer, my lord. Why I was appointed, my lord, they have justified.
Yes.
Next, loss will turn to page 30. This is another proposal sent by the executive engineer, my lord, for my regularization.
Yes.
Then the additional chief engineer sent a proposal at page 31 to the undersecretary to the government of Assam in PWD department.
Yes.
These communications clearly indicates that, my lord, I was appointed by the authority. I have rendered my service on being satisfied with my performance. They have sent proposal to the, my lord, higher authorities for my regularization.
Hmm.
But, my lord, they have not paid the salary for the period for which I have rendered my service.
Are
After
you still working?
No, my lord. After I have approached this honorable court, they have, my lord, rejected my entry into the office.
So you were working from 1/1/2009 up to?
Up to, my lord, filing this writ petition, my lord, 2022.
Hmm. So your prayer in this present writ petition is to release your salary?
My lord, that is the only
Not the
limited prayer,
period
my
you
lord.
are working till,
Yes,
till you were
My-
released.
my lord.
So what is the affidavit say?
They said that, my lord, they, appointment ordered, my lord, they says that the appointment order, they did not find in the office record. And they admits that my proposals were sent by the various executive engineers as well as the additional chief engineer to the higher authority for my regularization. And I was engaged. But they did not find the appointment order as well as my joining letter. That is their stand in the affidavit. But the documents, my lord, which certifies that I was regularly rendering the services, they have not disowned. None of the officers, my lord, who issued those, my lord, the certificates, my lord, they have not disowned those certificates, my lord. My lord, finally, my lord, they made an inquiry at page 66. That inquiry report loss will find. It says this inquiry was made, my lord, pursuant to this honorable court's order, my lord. It says that, my lord, I was unauthorizedly engaged.
Page?
Page 66, my lord.
So you approached this court earlier.
No, my lord.
Then who filed this WBC 938?
This is the 98 petition. ma'am.
Oh, this is the 9.
Yes, ma'am.
Yes.
My lord, the inquiry report itself says that, my lord, they have not denied that I was working. They only says that I was unauthorizedly engaged. But my services has been, my lord, extracted by the authority for that period, my lord, for which I am claiming the salary, my lord. Otherwise, my lord, it will amount to violation of Article 23, my lord.
Yes.
My lord will just peruse the order dated, my lord's order dated 9/10/23. So, my lord, 9/10/23.
Yes.
So, my lord, there is a direction on us. There is already confusion regarding his appointment, my lord. The court has already observed it. And that is why there is a direction to go for a inquiry by the commissioner. That was the direction, my lord.
1 minute. Have you filed, have you
Yes, my
done
lord.
the inquiry?
That is in page number 58 of our running page number, my lord.
Running page 58.
58, my lord. Filed by that, we are filing additional affidavit. That's the inquiry report, my lord.
Page 58.
Running page 58, my lord. 66. 66. Change your name. My lord, now it is 66 pieces. The number is 66. 66.
মই এতিয়া ৰাতিপুৱা ঠিক কৰি পাৰিম।
66, my lord. 66. Now, my lord, this is the inquiry that we have conducted, my lord. So, my lord, what we have found, my lord? On scrutiny, it is found that it is observed that the official copy of the temporary appointment letter, which was supposedly issued by the executive engineer of the division, Sri such and such, who was in the division from 2008 to 2014, is not available in the division, my lord. At present, the executive engineer expressed his doubt on genuinity of the appointment letter. Second is, my lord, there is no sanction post of computer operator in the division. It was also observed that no records of official procedure required during such appointment were found in the office records. Reference to experience certificate, my lord, reference to experience certificate which were issued by different executive engineers of the division during this incumbency period were examined, and they were found to be issued by the division office for a period of this period, my lord. Now, conclusion, my lord, we have reached that. The third is very important, my lord. Based on the inquiry of the SC and experience certificate issued, it is found that Raju Bhuya was unauthorizedly engaged in office work for the period between this and this by concerned executive engineer. On that of that period who has already retired. Therefore, government has decided to take the action that is, my lord, on the thing. So, my lord, now the thing is that first thing is that there was no sanction.
See, the last paragraph,
Yes, my lord.
this court directed the commissioner and special secretary to cause an inquiry.
My lord.
Correct.
My lord.
The last particular witness inquiry of the superintendent engineer.
Yes. Yes. My lord, inquiry was done by these three, my lord, on top, my lord. Special commissioner, deputy secretary, then under secretary. This is a, my lord, committee, my lord. They have
So
done it.
this is a committee,
Yes, my lord.
but then they are basing their findings on the basis of inquiry of the superintendent engineer.
My lord.
This is the problem. There was a specific direction that the commissioner and special secretary should cause the inquiry.
My lord. My lord, maybe this committee has deputed.
I don't know. But then it is, the committee could not have deputed, this court has directly specified the commissioner and
My
special
lord, my lord,
secretary.
my lord. But it is again down below. It is signed by the
No,
commissioner,
no,
my lord.
that they have signed, that they have signed. But this finding
I understand. My
is on the
lord.
basis of.
I got my lord.
So let the commission secretary
My lord.
cause an inquiry.
My lord, my lord, I will ask the commissioner to immediately do it, my lord, and submit the report.
Huh.
I will.
My lord,
In-
during the inquiry, my lord, all the officers who issued those certificates, they were personally heard. None of the officers, my lord, refused that, my lord, those certificates were issued. None of the officers, my lord. All
No,
the
there
officers.
are some issues that the procedure laid down
Yes, yes.
for appointment was not followed.
Yes, yes, that is true, my lord. That is true. Appointment procedure was not followed. But, my lord, that is why, my lord, I am not praying for any regularization, my lord.
Even for
Only, my lord, on the-
salary, my lord, Supreme Court has settled, my lord, on such appointments, what is to be done, my lord. I have a law, my lord, I can place it, my lord. The Supreme Court
don't-
categorically says that no salary for such appointments.
That's fine. That is already a settled position of.
Settled position of law, my lord. I have this judgment with that.
That will amount to violation of Article 23, my lord.
That is what
Structured
they said,
service.
if we,
Which case you are referring?
Mamata Mohanty, my lord. Just one paragraph, my lord, I'm just placing with your lordship, 36. It is categorical, my lord.
After Mamata Mohanty also, my lord, there is many judgments.
But this is still holding the field, my lord. It is not overruled, my lord. My lord, para 36.
Mamata Mohanty.
Therefore,
Yes,
it is settled legal proposition that no person can be appointed even on a temporary or ad hoc basis without inviting application for all eligible candidates. If any appointment is made merely inviting names from employment exchange, here they are talking about employment exchange. It is not even the case of the petitioner, my lord. We don't know even how he was appointed. Employment exchange or putting a note on the notice board, etc. That will not meet the requirement of Article 14 and 16 of the Constitution. Such a course violates the mandate of Article 14 and 16 of the Constitution of India, and as it deprives the candidates who are eligible for the post for being considered. A person employed in violation of these provisions is not entitled for any relief, including salary. That is what court has held, my lord. Such appointments, my lord, he is not even entitled for any salary.
But thereafter, my lord, in many other judgments, my lord, the apex court held that, my lord, if service is extracted, my lord, they have to pay the salary for the period the service is extracted.
This is all right. Except this inquiry, I don't know. It was done by the superintendent.
I got my lord, my lord. There was a direction, maybe they didn't understand, my lord. That is why they deputed, they made a committee headed by the commissioner, and they deputed SC superintendent engineer to look, file a inquiry report, and on that they have taken a, my lord, decision. That is, my lord, technicality, yes, there is, my lord, there is a direction to, for the commissioner to go into the field and make an inquiry.
Yes.
Yes. That, my lord, they have maybe misread, my lord. My lord, I will again tell commissioner to do it by himself.
Heard Mr. Ezekiel and the council. Also heard Mr. Ardha, the additional senior government. Appealing for the, you are the additional senior government or the standing council?
My lord, standing council, my lord.
The standing council.
PWD, my lord.
PWD. Stop. This court on considering the controversy with regard to the genuinity of the appointment letter of the petitioner, comma. This court on 9/10/2023 directed the respondent number 2 oblique the commissioner and secretary to the government of Assam. PWR,
R, my lord, PWRD.
PWRD. Within bracket. ESGT B. To cause an inquiry into the matter. And thereafter file an affidavit in opposition within a period of 1 month from the date of the stop. For consequent that, comma, the Deputy Secretary to the Government of Assam. ESPT branch confidential cell filed an additional affidavit in opposition on 19th December 2023. Annexing a copy of the inquiry report. Stop. However, on perusal of the inquiry report, it appears that the report was based on an inquiry of the superintending engineer and not by the commissioner and special secretary to the government of Assam, PWRD, as directed. Stop. In that view of the matter, comma, the inquiry report dated 8/11/2023 is not accepted. And the respondent number 2 oblique commissioner and secretary to the government of Assam, PWRD, within bracket ESTT dash stop B, is directed to cause an inquiry by himself in the matter and thereafter file an affidavit within a period of 1 month, 1 month from today. List the matter after 4 weeks.
Just to fix it, that matter.
Let us see. Let them file the affidavit.
Without fixing, those are not listed, that is the problem.
Today is what day, 23rd.
On 30th.
This is the matter on 30 May.
Obligation.
You can take your book.
Item 326.
Item was 6, madam. I have not filed an affidavit, madam. This first time come, before this one court, madam. It was 6, madam.
Yes.
So, we pray this, madam, for this time we can to file affidavit.
He said.
Yes, Pathak.
The affidavit was filed, my lord. Affidavit was already filed. Maybe they want to file a additional affidavit. No, don't.
Item 6.
No, it will.
Item 6.
6, madam.
No, it will.
No affidavit is. filed.
My lord.
I have
Otherwise, the facts, my lord, are actually decided in a series of different cases.
maybe, my lord.
So it's mostly a question of law as to what policy and what would be the interpretation of that policy as to retirement on 30 years of service. Anyways, my lord, we cannot object to the prayer, my lord.
But Mr. P. Pathak, learned counsel for the petitioners. Also heard MS B. Sharma, learned CGC. Mr. S.K. Medi, learned CGC, appearing for the respondents in WBC number 4308 of 2023. Praise for
4 weeks time, madam.
4 weeks time to file affidavit in opposition. Stop. Prayers allowed. Release the matter after 4 weeks. And you? Okay, then you say also had on top, with the MSB Sharma, Then the CCC in WBC number for the respondents,
22.
for the respondents in 1130/2022. Mr. PS Padajara, Leonard CGC for the respondents in WBC 2368 of 2022. And Mr. AK Data, Leonard CGC for the respondents in WBC 2573 of 2023. Huh? After that, you say Mr. SK Mehdi,
Matter will be fixed on 3rd of June, my lord. If convenient, my lord.
No, no, because the issues are otherwise settled.
Okay. Don't say list of four. Say This the matter on 30.
No, but fourth zone would be better, it would be a hearing. date.
Election detail.
Oh, fourth is the election results. It's a result, man. Result in the book.
We file affidavit, man, then
Whatever,
file it.
deeply obliged.
8, 9, and 10.
Yes.
Your Lordship, I am serving in Food Corporation of India, and I've been charged for shortage in stock while working at the food stock depot at Bindukuri in near Tezpur. My job as a SAID in charge of SAID number 1 and SAID number 3 was I was looking after the entry of stock in the store, and then disposal of the stock from the godown. But the charge that has been leveled against me by the management is that I have made the management to suffer a storage loss for sale number 1, 1.96 quintals, and sale number 3, 353.3 quintals.
You have the records?
We'll have to call for the reports, my lord.
Disciplinary processing, you should always bring the records.
My lord, can it be taken upon some other day? I will be equipped with the record. There are 3 matters, 8, 9, and 10.
All these are same matters,
So same matter.
all dismissal,
No, not dismissal, my lord. The minor punishment.
minor punishment,
Recovery of rupees only 1 lakh.
recovery of 1 lakh.
Hello, Your Lordship, I have to say, this is from the, I am quoting, whatever I have quoted, I quoted from the order of the reviewing officer.
That's fine. But then what we want to
So
see
can
is
it be
the,
taken up on 16th? That is Thursday, my lord, hearing day. I will be equipped with the, well, it has to be called from the, I think it belongs to Tezpur. This thing. Tezpur
okay,
Apple.
heard Mr. GK Gupta, the responsible. Mr. BK
BK
Singh,
Singh.
the standing council shall produce the reports. Stop. Release the matter on 16th of June,
16th of May.
16th of May, 16/5.
My lord, to produce the record, it may be recorded now. To
I've
cause
said to produce the,
obligement.
16.5.
16th of May.
shall produce the records in origin.
Yes.
11.
Please, Your Lordship.
Yes,
My lord, so involved in this case, Lordship, the petitioner was selected and offered appointment by the respondent ONGC for the post of junior technician jail in Assam zone under reservation a benchmark disability category for hearing impairment having 55% disability, my lord. But though offer of appointment was issued by the Chief General Manager HR ONGC, but the medical officer of ONGC denied to give medical clearance for giving for joining as petitioner was given disability certificate 55%, though given 50%, but valid up to 25/10/2025. That is the trust. Now, my lord, list of dates if we go, my lord. Lordship, I have given this a list of dates if you're kind enough. Lordship may peruse this and I can see that. A list of dates if we get 2/6/2001, 21, the petitioner passed.
What list of dates?
This I have given for easy edition, like this list of dates I have given. This way. That is
Even earlier?
yes, very beginning I have given. But it will be easier for us. I have given, lots you got it. Isn't it?
Issues involved, that one.
Yeah, yes, my lord.
Ah.
Yes, involved. Here I have first paragraph I studied, or I have read. List 2/6/2021, the petitioner passed and awarded national test certificate for medical digitalization by the Ministry of Skill Development and Entrepreneurship, Director of General Training, Annex 4, page 26, Miller. Next, 25/5/2022, disability certificate issued by Medical Authority by Chipsagar, Assam to the petitioner certifying hearing impairment of 55% temporary disability valid up to 25/10/2025, Annex Section 7, page 20. Just I am going through this, and thereafter I will go by is Prajesh Miller. Then this was the disability certificate that issued on 20 up to 25/2010 by that is a board medical authority proper authority is given. Now there is a then this will get 7/5/2022 to 25 submission of online application as per Gov. Advertisement number 0222 issued by ONGC for requirement of non-executive post of various zone, including Assam zone. In the said advertisement for Assam zone, 9 posts were advertised for the post of junior technician DGL, and out of the said 9 posts, 2 posts were reserved for disability category of category B, DHS. This were hearing melody, that is impaired of hearing. Accordingly, the petitioner applied, Annex 8, page 36. Thereafter, my lord, in advertisement, not for candidates or advertisement, not for candidates were given. And actually, it is given region grounds for persons with benchmark disability. Certificate of disability should be issued by the notified medical authority in the format prescribed in the Rights of Persons with Disability Rules 2017. The minimum degree of disability of a person to be eligible for any concession benefit, that is as per advertisement, that is requirement is 40%, Miller. I have 55. On that point, we are clear. Date of interview, a 10/8/2022 date of interview. Petitioner issued e-admit card. Accordingly, he appeared in interview. 11/1/2023, as the petitioner was qualified and shortlisted under category PW, document verification was carried out. 11/1/2023. 16/5/2023, issued apart for appointment to the petitioner by Chief General Manager HR ONGC, that is Annex 11, post 47. 22/5/2023, appeared before medical officer SS ONGC. The medical officer declined for approval as according to him disabled certificate of the petitioner valid up to 25/10/2025. Affidavit in opposition filed by ONGC earlier. According to the respondent, ONGC petitioner cannot be allowed to join as the petitioner was issued a temporary disabled certificate valid up to 25/10/2025. Affidavit in opposition filed by respondent of that is by Health Department. 5. Chairman District Disability Board, Chipsagar, Assam. According to the respondent 5, the petitioner was recommended for 3 years, 5 months, and same is valid up to 25/2020. After expiry of first validity period, the petitioner will have to apply through online as per guideline, and thereafter he will have to appear before the board for proper assessment. Board will decide issuance of permanent certificate accordingly. Thereafter, this up to this your lordship heard. Thereafter, your lordship inclined to go for, as my certificate is valid up to 25/20, your lordship
inclined to give that, he may be given appointment of October, subject to some affidavit instructions required from. Accordingly, he has filed. Now my lord, I'll go by this petition now again. This is the crust of the case, my lord.
1 minute. Have you filed your affidavit?
Yes. Yes, filed. Affidavit from you. 7024. Lordship 7024 is filed.
1 minute.
Lordship, today. No, typing mistake Mishwa ke. भूल रहे थे. Yes. This will get to you. 70.
Yes.
Now, my lord. Now, he's putting question to my decision certificates. My lordship has got it. That this it is to here, lordship, to be clarified, because up to previous points, it has been cleared before, lordship. Now, lordship just now gone through this on 70/20/22 affidavit, which is filed ONGC, paragraph 5, subpara. It is to be here, it is clearly mentioned, the advertisement, that the advertisement number so-and-so issued by so-and-so for person with benchmark disabilities, certificate of disease should be issued by notified medical authority, format prescribed in the right persons with disability 2017. Minimum degree of disability for a person to be eligible for the insurance benefit up to 40%. Admitting. Now, next para, it is contradiction. It is stated that certificate that 25/5/2000, which was issued before 3 days, the last date of applying for post of junior technical certificates, that the petitioner is only temporary disability of 55% in respect of petitioner's years with the data valid up to 20. Here they want to say just before 3 days of advertisement, my certificate was issued. That is why question of doubt is being raised by them. It is not at all bona fide. Had ONGC had told me, I'm going to appear with given advertisement for this post, you just clear for this. Is it so? No. It was issued before, well in advance, at least for admission check for in their sake. This 3 days before giving advertisement. I have that's that point. Next point he is taking that in paragraph 7, he is taking the section 2 as of the right of person with disability briefly act herein, the means person with long-term disability, since the certificate with petitioner itself clearly states that the disability of the petitioner is temporary, having its validity up to 25/20 only, as such temporary disability of petitioner does not cover. Now, second part also is important. 8, section 2, ZC defines special disability, which means disability as specified in the schedule of 1 Act. Clause 1C schedule of the Act defines hearing impairment as per 1C of the schedule of the Act defined hard of hearing means person discharged 60%. Now, in this regard, I have to reply. Advertisement, what was the criteria? We have to see that, my lord, not by this now. Whatever criteria. Now I'll take a lordship to first page regarding disability certificate which was issued, page 27, my lord, my petition, annex of 5.
$27 or $29?
29, it is a continuation, because members are 29, my lord. Lordship may go to 29 is your certificate. Your lordship will get it. Lordship, may I read?
Yes, page 27.
Yes, 29, lordship, because it is a continuation, there is a final outcome is 29. That is why if we go through 29, it will work out. Disability certificate. Department of Empowered Person with Disability, Ministry of Social Justice Empowerment, Government of India. Disability certificate, issuing medical authority, Sibsagar, Assam. Certificate number so and so. Date 25/5/22. This is to certify that we have carefully examined Shri Ankush Saikia, son of so and so, date of birth so and so, registration number is also given so and so, resident of so and so, district whose photograph effects have satisfied that he is a case of hearing impairment. B, the diagnosis in his case hearing impairment. He is 55%. He has 55% temporary disability in relation to the years as per the guidelines. So and so, guideline of the purpose assessing the extent of specific disability personally included under RPWD Act 2016 notified by Government of India by number so and so, so and so. This certificate document is 3 years for 5 months. Therefore, the certificate will be valid up to 20 years. These are submitted following documents. So and so, this is the certificate. And another unique disability certificate also given. Now we'll go for advertisement. What is the criteria requirement, my lord? Lordship, advertisement starts from page 31, annexure 8. Particularly, and page 36, my lord, if we go by page 36, head note, you will see, lordship will get A8 ONGC Work Center for in Assam. Lordship got it. Now, I'll take your lordship to CL number 15. Lordship got it. 15, category so and so, junior technician diesel, total post. 2 is reserved for disability categories. 2. Lordship got 2 is reserved category, but now criteria is given, my lord. Criteria is given in page 41. Lordship got it.
Yes.
Had note your lordship in the last day G, note for candidate. Now, applicability for me, that is 18, my lord. Right hand corner, that is 17, 18, my lord. Lordship, for persons with benchmark disability. Lordship got it.
Yes.
Yes. Certificate of disability should be issued by the notified medical authority in the format prescribed in the Rights of Person with Disability Rules 2017. Rules 2017, the minimum degree disability for a person to be eligible for any concession benefits would be 40%. Now, my lord, will take to Rule 17, my lord. What? Now, Rule 17 says, lordship, the right of persons with disability Act 2016.
section,
will go by 18. Application, chapter 7, certificate of disability, section 17, application for village. Now 18. 18 will be applicable here. Lordship got it. Issue of certificate of disability,
1 minute.
page, if it is same, 58.
Rules.
Oh, that is rules.
You are going for the rules or the act?
Rule 2017.
Rule 18.
18, Miller.
Oh.
How, what manner it is to be given, disability certificate. Issue of certificate of disability. On receipt of an application under Rule 17, the medical authority or any other notified competent authority shall verify the information as provided by the applicant and shall assess the disability in terms of the 11 guidelines issued by the central government. And after satisfying himself that the application is a person with disability, issue a certificate of disability in his favor, Form 6 is 5, 6, and 7 as the case may be. The medical authority shall issue the certificate disability with a month from the date of receipt of the application. The medical authority shall, after examination, issue permanent certificate disability in case where there are no chance of variation or disability over time in the degree of disability. Issue of next point, Roman 2. Issue a certificate disability indicating period of validity in cases where there is a chance of variation over time in degree of disability. Now, here is still this section clearly says, those who are having not permanent can be given to such one, but those who are having this one certificate disability indicating person validity in cases where there is a chance of variation disability. And they want as per this act and rules. This is a fully complied. Because this is given hearing impairment cannot be given at a stage that will be said by health department. What have I understood? Because hearing department initially is to go for temporary under clause 2 they will give. Thereafter it will be given permanent. And second point is, your lordship, 19 if we go, certificate issued under Rule 18 to be generally valid for all purposes. 19 says, a person to whom the certificate issued under Rule 18 shall be entitled for apply for facilities, concession, benefits, for persons and disability under the scheme of government or non-government organization funded by the government. Meaning thereby, whatever certificate issued under the provision of Section 18, this benefit, they will get it. Now, this certificate is issued under provision of this 18. Now, my ONGC now, respondent ONGC cannot go by, they are going by the definition. Once section is clear under what provision is required, thereafter can they change any section or any additional provision? Because they have clearly said, and under this provision, my certificate is valid one up to 2510. That is why your lordship was kind enough to consider the case and earlier on basis of submission. Okay, you give up to 2510, 25. If he's found that he goes below 40%, drive him out. If he's above 40%, because their criteria is 40%. If above 40%, you keep him, or if he is thrown out. That was your lordship stand. But only now, only that instruction was required that affidavit has come. Whether by this additional, this affidavit 74, which is filed, which that point is not covered up. Because I am being, my certification issued under the provision manner what is required by ONGC. I have received. Now, this is my stand, my lord. And that apart, all documents, though it is initially online, I have document verification after giving offer of appointment. I have shown all documents to them. It is not that they are saying that it is an online document. That is why. Yes, fine. It was online application. But when it was offer of appointment was issued, document verification was there. That too by concerned officer. And that is why this was chief medical officer concern has given a offer of appointment. This is not a hide and seek that we have, I have, online, I have shown something. When you document verification, I have something, nothing like that. Only medical officer, whatever, when is you, he himself is taking view. Generally, whatever, my lord, generally we, whenever appointment is, your lordship is very much, ever appointment is given, there will be a police verification and there is a medical verification is there, all post. But medical officer has failed to consider that this document verification was by higher authority. Thereafter only offer of appointment was given. That's under provision of law. Now, lordship, this is the my entire thing case is this. Now, according to him, I should go for again medical, appear before medical board. I don't know why, where, under what provision he's saying, I don't know. According to him, that I should go for again for medical board. There's no provision because already it has been given up to 25 tender. Now, in this regard, my learned friend also clear on that point, whether it went, if there is a provision, definitely I'll go, my lord. Why? Because my disease is there, I'll appear before this. But there is no provision as per my knowledge. But that is be cleared by learned friend who is appearing on behalf of medical board. If he says, okay, it can be, we'll go for, why not? We'll go. But there is no provision. And your lordship, we are claiming it is not that up to 2510. In very beginning, your lordship is decided that only lordship wanted to know something from him. There is but 25, there is no doubt in that up to 25/10/2025, my certificate is valid. And under provision of 18, I have just now I have gone through 18 under provision 18(2) Roman 2, I have been issued. There is no provision if it is there is a chance of decision. Thereafter it will be given. Thereby they cannot say as per provision law, provision of your own criteria I have applied. That is my humble submission before lordship. Now because if I keep on arguing, nothing will come out, and he has to argue, and let them argue. Then if required again, I'll argue, Miller. My only this point should come up. Some health department should clarify whether I should go for this one. Thereafter, it may go for that. But he cannot. Again, I'm submitting, which is view is taken by respondent ONGC that as per definition, which is mentioned in section 2, the disability means so and so. No, you cannot come out now because own criteria you have sent under provision of rules. 18 I have now. Let them argue, Miller. Affidavit of it to Punadi. 1 to 4, 8 to health affidavit to the other point. Only lordship only health department has given that is chairman this one. That let me complete the pleadings, otherwise that will be incomplete pleadings. Now this is filed on 29/2024 by the chairman district disability picture here.
Which affidavit?
Affidavit filed by my lord chairman district disability board Chipchagar. On that is my letter, it says on 29/2004 I think, or 2024 affidavit
Affidavit filed
by one Dr. Bhupendra Kumar Das. Page 78 and serially, I think.
78.
If you go by 78, my page, it is saying 78, lordship. Affidavit filed by respondent number 5. Lordship got it? Or it same?
Yes.
Yes. Here, I, Dr. Bhupen Kumar Das, son of so and so, I being the chairman of disability board, Chipchagar, have been implemented as one of the instant petition and being the well conversant with the fact and second of the case, I'm competent to distribute. A copy of the instant petition filed by the petitioner has been served upon me, and after going through the, I have understood the answering First, the answering deponent, instead of giving paragraph-wise reply, writ petition deems it appropriate to place relevant material facts and proper adjudication of the issues involved in the writ petition. That the answering deponent begs to state that, as per record available in the office of the undersigned, the disability certificate in respect of Sri Ankush Sheikha, which was issued by certificate number so and so and 25 dated 25/5/2002 against the case of hearing impairment with 55% part. With 50% temporary disability as per notification of Ministry of Social Justice and Government of India. It is pertinent to mention that as per clause 40 and 2 of the notification dated 30/12/2009 issued by the Ministry of Social Justice and Empowerment, it is clearly stated that a permanent disability certificate can only be issued in cases where there is no chances of variation over the time in degree with the disability and in case where there is any chance of variation over time in the degree of disability, period of validity in the certificate shall have to be indicated. In view of the above, it is respectfully submitted that the certificate in respect of Shri Ankush Saikia has been recommended by the District Disability of Shivsagar 3 years 5 months, and the same is valid up to 25/10/25. After expiry of the validity period, writ petitioner Ankush will have to apply through online as per guideline. Thereafter, he will have to appear before the board for proper assessment, and board will decide for issuance of permanent certificate accordingly. And copy of notification, this one, then nothing. This is their vision. As per, according to them, as per that is guideline, initially for this type of disease, we cannot give, but thereafter we will give this one. Now, valid after we will give permanent this one. This is my humble submission before Lordship. I am taking risks. 25/10, suppose I am being declared fit, my service will go. Definitely I have to go. I'll appear. Definitely I have to appear, my lord, as per this policy. I'll appear before. If it goes below the reservation percentage, I'll face my consequence, my lord. Till that to be considered, because this honorable court, while a prima facie case is made out, balance of convenience for me, that is why our honorable court was pleased to grant me keep one post vacant. That is why what keep is one case. Now that post is keeping vacant. Now, my humble prayer before Lordship, if ONGC give me up to 25/10/25, they are not going to lose anything. Not going to lose anything. Rather, they will get the service. Without giving service, I will not take the salary. And after 25/10, my disability percentage goes down, or I am declared fit by the medical board, they can liberty to your lordship may observe. Thereafter, he may be thrown out from service. That observation can be there, and I'll go out. Otherwise, it is not that it is a ONGC is conducting selection only once when at 20 years or 10 years. It's not that. Every year conducting. Their post will be vacant. If I'm relieving, I'm be thrown out. The post will again, they again go for the vacancy. It is nothing like this. Only citizen of India being a disabled person is waiting for with hope and extensions. It's my humble submission.
Not on this particular query, Lordship, on last occasion, Lordship directed to file me the affidavit, my lord. I filed the affidavit, and there are 8 I have clearly stated, my lord.
You're going on the basis of that
Temporary
temporary.
medical certificate.
Normally, a permanent disability certificate is not given
Yes.
unless there's no chance of variation,
Man,
correct?
man.
When there is a chance of variation, a temporary disability certificate is issued
No.
in terms of Rule 18.
No.
Correct? Now, he has a valid
25/10/2025.
up to 25. You appoint him up to 25/10/25, he will go for a medical checkup. If his disability comes below 40,000, 40%,
No.
you throw him out
Yes,
and make a re-advertisement.
yes.
My lord, on this point, my lord, my submission is that, my lord, on principle, we are arguing this case, ma'am, because it will give a bad precedent in the next ensuing, my lord, our equipment, because
under this scheme of this act, my lord, and the guidelines have been framed, my lord, how and what manner this certificate is to issue. And in such cases, my lord, lordship, hearing impairment, in such cases, both eyes, ears should be, my lord, impaired, both here. We found in our assessment by the doctors there, my lord, only 1 year he was having the problem. So therefore, this is perhaps the reason that permanent certificate, disability certificate is not issued. He has been issued temporary certificate. Now, my lord,
No, are you
So-
questioning the validity of his disability certificate?
my lord, on the ground, my lord, that being this is a temporary certificate, we cannot give an effect to this, my lord. Because lordship, the guidelines, as per the guidelines, lordship, as per the guidelines, can you see, my lord? Guidelines have been framed under section 58. So,
Who is the guideline?
yes, in the act itself, my lord, the guideline is appended, my lord. Under section 56, guideline have been framed, my lord, guidelines
Who is the
for,
guideline?
this is last part of the book, my lord, same book, my lord, last part.
Yes,
After 114, 115, my lord,
page.
Oh, বেলেগ এখন কিতাপ আছিল নেকি?
এইটো দি আছো অকে নেকি দেখোন
Oh, sorry. 115.
এইটো নেকি
Yeah.
এইটো নেকি
115.
এইটো হয়নে
ঠিক আছে।
মোৰ ওচৰত নাই বাৰু লৰ্ডশ্বিপ কৰিলে হৈ যাব
Yes.
My lord, the nature of certificate, what are the nature of certificate they are to issue, my lord? 136 now, my lord.
Page?
136 one. Guideline was framed under section 56 of the 19.2 man. Nature of certificate, the medical authority will decide whether disability certificate to be temporary or permanent. The disability shall be permanent to be certified. The certificate can be temporary if condition is likely to worsen after for a specific purpose such for pursuing education. The need for reassessment if required should be clearly mentioned in the certificate with different. In certain cases such as CONA's developmental defects, operated congenial contact with corneal decompensation, operated congenial glaucoma with cornea, etc. The patient especially can be issued a temporary certificate. So temporary certificate will come later on, my lord. The first, that the medical certificate assessment of the medical board has to show his both ears are damaged. We have filed in the repetition that our doctor what they found, my lord, page 58 of the repetition. From the page 58, our assessment he has annexed in the repetition, my lord. Page 58, my lord. Down below, lordship, serial number 6. Down below. Hearing. Left ear normal. Impaired. My lord, correction is impaired. This is impaired. We found impaired for the reason mixed defectus conductive dysenia temporary. We also found temporary in respect of 1 year. So permanent here under the scheme, my lord, of the act, permanent will come if both the year has got some problem, because specified disability, what is specified disability, my lord?
See,
My lord.
serial number 5 is nose, correct?
Yes.
Page 58.
my lord.
Under E, mouth, nose and ears.
Yes,
Serial 5 is nose.
my lord.
That is normal.
Correction, we found a lot, we have also get that instruction, that, type copy, my lord.
Hmm.
Uh,
Hearing impaired,
yes.
six. Hearing
Six, hearing
impaired.
impaired. Then
No,
tympanic membrane, right ear defective, left ear defective.
yes. Well, impaired is and defective, it can be distinguished from the act itself, my lord. Impaired means hearing capacity. Defective means he must have some disease, some.
See, we are not going into all these
Yes, yes.
technical issues.
Yes, my
See,
lord.
the medical department or the authority which is supposed to give the
Yes.
certificate,
Man,
they have issued the certificate.
That is board.
Now
my lord.
there's no question
Yes,
of going into the details whether the certificate issued is correct or wrong.
man,
He has been issued a disability certificate temporary
yeah.
up to 2020.
yes, my lord.
Okay. Now, on what basis are you saying we cannot give him appointment? Because it is only, your ground is that it is only a temporary
Temporary.
disability certificate.
Yes. And the conditional appointment may not be, there is no provision for conditional appointment.
Oh.
Now, my lord, this specified disability has been, my lord, defined under section 2ZC. And as per that, my lord, specified under the schedule. Disability specified under the schedule. What is the schedule, my lord? Kindly see, my lord. Schedule at page 48. My lord, now page 49, see hearing impairment below, my lord.
1 minute. We are on different books.
Oh.
The dead books also. it is
Earlier
there.
book, my lord.
Specified disability,
Yes.
You may go to my books. which are
Specified
given.
disability, my lord.
yes.
Then, C, clause C, my lord, hearing impairment.
Mm.
Then B, my lord, CB, hard of hearing means person having 60 decibel to 70 decibel, hearing loss in speech frequency in both ears. Now, it is not discernible whether from our assessment, it is defect only, impairment only in 1 year. Now, my lord, if that be the certificate issued to, my lord, in 2022, more than 1 year over, my lord. So, as per, my lord, guideline 25.3, there is a provision for guideline, second guideline.
Yes.
In the page 146, my lord, from the guideline,
Hmm.
25.3, top.
Hmm.
Neurological conditions which are reversible and without sequel are not certifiable only. Neurological conditions which are permanent are certifiable. Permanent certificate, disability certificate can be issued in irreversible or progressive cases. If need, in specific cases, a re-evaluation of disability can be done after a period of 1 year. So from these only I was, my lord, suggesting that let him go before the medical authority because certificate was issued and there is no specific, my lord, assessment as to from the certificate, my lord, whether he was having the hard of hearing or impairment in both ears. Certificate is a page 29. Then he'll apply before the authority and get a fresh certificate, my lord. And on the basis of the assessment report of the certificate, my lord.
Later on.
No. Because, my lord, it will otherwise, my lord, from some same nature of certificates, we have not, my lord, accepted for other candidates whom we have rejected. Suppose,
You have
after
rejected-
appointment.
You have rejected. That is a different thing. Now he's before the court.
Before the court.
Yes. Now, my lord, in such cases, in my understanding is that, my lord, if this temporary certificate is allowed to continue, my lord, or allowed to, my lord,
See. This temporary certificate is only after 25,
25, my lord.
2025.
my lord.
After that, if his impairment comes down
Uh.
below 40%, I'll make my order clear.
Yes.
That the petitioner will be thrown out.
Even my
If
lord,
he comes with a permanent disability certificate thereafter, he'll continue.
yes,
My lord, that
Why
consist-
should the petitioner be victimized?
yes.
Just because he has a disability, temporary
Temporary
disability certificate?
My lord, since, my lord, this will affect in the future,
What-
consideration.
What
We
effect?
are talking
Therefore,
about
we are
future.
arguing-
We are suffering in present.
Therefore, we are
We
arguing
have
the case, my
future.
lord. And same issue, my lord. Same issue was before the Honorable Punjab and Haryana
We cannot go in there.
division bench. So since this is a division bench judgment, my lord, therefore.
Here, my lord,
it-
only
it-
question is coming before going
It-
decision. Is it legally, if you, now I'll go by law point, factual. Whether he have challenged this board, once is given by board, one medical officer, he is simple MBBS. He is declining, let it be, he's declining board decision, your lordship is very much word. This is given by board, number of addition one by medical board as per ministry's guideline. Now, illegally, even for the argument check, if we admit also for argument check, not admitted, for argument check, I'm submitting. This affidavit is supplied to him, no point is given. And second point, he is taking the precedence will work out. Okay, fine. If you hearing about precedence, you clearly says when the criteria is given, you give the under provision of section 2 of ZC or whatever C, you have to be this one. You have not mentioned. Now, after coming here, when a matter is before your lordship, before our honorable court, before your lordship, now he is challenging because you have to go by criteria. That too, he is challenging. Very interestingly, my learned friend, of course, appearing on behalf of department, that is so. Whatever instruction, I also appearing, we also somewhat problem. The problem is coming, my lord, he challenging the certificate which was given by one board. Now, can he? That too, after giving a firm appointment, and we have approached also, we have given, my lord, thereafter petitioner, whenever this one, there is a rejection, we approach also, a statement we have given me, here paragraph 18, thereafter petitioner approached the chairman of district disabled to issue permanent disability, but the chairman of the said medical had declined to issue permanent certificate as there is no provision of rule to issue permanent certificate earlier, a medical had already issued this one. Now, clearly, it is mentioned, moreover, it is a law point if you go by legally, if you go, now it cannot be challenged. It is given by board. If, okay, fine, three members is given. If 5 members should have taken, or 4 members have taken, then only question. Now, one medical officer is challenging this impairment. Now it will be very dangerous situation, my lord. The one medical officer is giving this one and he is talking about future.
He may not hesitate
My
to
lord.
go there, my lord, for.
Hesitate means good. I have
No, no, agree. Moreover, my lord.
I'll not go now
uh,
then. Your lordship
the
will decide.
judgment I have placed, my lord. This is because this is a division bench judgment, therefore I
Have you
was.
given him a copy?
No,
Uh,
not this.
I have not given. my lord.
No.
Give him a copy.
I-
He should-
No, lordship can go through. If it is, lordship will decide because it is a matter already. If your lordship inclined to give me also, I'll hardly work for 1 year only. As it is, I'm suffering from disabilities. Who man is suffering from some disability, he only knows what difficulty is coming. He may
No,
be
it is-
it may be very, disability may be very small, but man is suffering. He knows what is problem, my lord. Standing here, we do not understand because we do not have that disability.
Well, here
That
is
is why
also the same.
lordship will
case.
decide if
See,
it is.
Here,
Well, here is the same case.
here the petitioner is 9%, 9%
No, no.
disability.
Disability.
First page, my lord, second para, my lord.
Yes,
Disability was assessed as 40% to 50%.
Hmm.
My lord.
then continue.
Yes,
no, continue
yes,
reading.
yes, yes. the respondent university rejected the petitioner's candidacy on the basis of medical board's report, which was on 13/7/2015 opined that she was suffering with only 9% disability, which is non-progressive in nature. Malad, this is the assessment by the university, but her certificate was, Malad, her certificate was 40% to 50%.
Oh.
And our certificate is also, Malad, we have found disability in all respect, Malad, in 1 year. Now, 1 year is, Malad, okay. In such case, Malad, she or he can hear very well. The petitioner, on the other hand, relied upon the medical. Now, my lord, the paragraph which is important, or where my lord lordship has held, what are the certificate, is page 8, my lord. About the certificate, temporary disability certificate, my lord. Second para, page 8, my lord. The classification and notice above clearly contours around a permanent disability, the weight of which an individual has to carry through his entire life. It does not talk disability which is a temporary appellation liable to be disabled or be reduced either with the passage of time or with appropriate treatment. The reason is to apparent as such a person with temporary disability carries neither weight nor stigma which a person with permanent disability carries. When the provision of this act is read with the aforesaid extract rules 18(3), 1 and 2, it becomes abundantly clear that certificate of disability means a certificate of permanent disability. For the very same reason, 1995 Act also has to be held to be referring is permanent disability. Learned Counsel for the petitioner has made about aforesaid extract 18(3), 1, 2, contained to permanent disability does not find mentioned therein. We are of the opinion, my lord, it is important, my lord, that in view of the category provision of the act, there are 3 categories of person with disability has been set out, which suggests a long-term disability. There is no escape from such a conclusion of the act, which the rules do, prescribing a preferential operating for those with permanent disability alone. The language of Rule 18(3)(1) is defective, and we would read it to mean that the medical authority shall, after a due examination, issue a certificate of permanent disability. The word permanent disability occurring in clause 1 is to qualify the disability and not the certificate. For the reasons of the continuous noted that where there are no signs of variation or disability over time in the degree of disability, simultaneously clause 2 states the issuance of certificate of disability indicating the period of validity, there is any chance of variation over time and degree. Clause 2 therefore also talks a permanent disability, but with chance of variation and reduction in degree. The
That's what-
certificate.
That is what.
That is the.
Yes. Now, my lord, next, continue, my lord. The certificate of issued by so-and-so authority indicates percentage of disability as 40%. The body with nature of disability as temporary. Here, my lord, certificate is disability 55% and the nature is temporary. So, in this view of the matter, respondent sense cannot be faulted out. We have taken this there, thus then was the respondent that temporary certificate we cannot give any, the admission. Here also, temporary certificate, we cannot act it upon the certificate.
No, this is not applicable.
Not applicable. Why? Because, my lord, first and foremost thing, law is, one citation is given.
You have a silo.
No, I'll not see because I have heard. Facts is not before your lordship. Suppose, no, I'm telling you, now this is not applicable, my lord. Now it is not applicable. And moreover, it is not a Supreme Court judgment.
Right, division bench.
Maybe it is not bound. The court is not bound to accept division bench judgment, or either it is not our courts because we do not know. But lordship, by the going through, it is itself clear that this will be not applicable for this case. Now I'm leaving your lordship
You
now.
read the last paragraph.
Yes.
Read the last paragraph.
After giving a thoughtful consideration of this aspect, we are of the opinion that it would be a travesty of justice to deprive the petitioner who sons to complete her course purely on equitable ground without setting a precedent, but simply with a consideration that the petitioner has studied for 1 year and particularly attended the class for a second year. And particularly when the seat of her remain unutilized, we would deem it appropriate to direct the college to permit her to complete the course. Needless to say that the petitioner would have to satisfy the requirement of college and acquire eligibility of the participation in the remaining course.
That's what they're saying.
The
That's what I'm
remaining
saying.
course.
That is it.
He'll have to show his eligibility after 2010,
Yes,
2025.
my lord, that is your very beginning, your lordship
My lord.
inclined to give this.
My lord, since lordship has, my lord, also deliberated on the point, this kind of cases has a my lord, chance of variation.
So
And
that
this,
is why I'm
this,
saying,
this certificate having been issued in 2022, my lord.
Yes.
We are in 2024. So therefore, as per clause 25.3, my lord, of the guideline, my lord, in my humble submission, he may my lord, get a recheck from the authority, my lord, 25.3, my lord.
I'm closing this case.
Yes, my
My
lord,
lord.
oblige, my
You
lord.
appoint him.
And lordship, moreover, in the advertisement, there is nowhere mentioned that temporary certificate will not be accepted.
Yes.
So can now they go beyond the advertisement? They will
No,
have
no,
to act.
advertisement we have said, my lord. Advertisement, what we have said as per the rules.
Lord.
No, this is not the correct submission, my lord. Because, no, because from the advertisement, first page 31, my lord. Second paragraph, we have said this is online application, candidate can apply. Third paragraph, can apply for the post of respective state as per the status, domicile, permanent residence, and the state subject to meeting eligibility. Now,
Eligibility,
to-
lordship.
for such post of my lord, person with disability, page 41,
Yes,
18, just now he
Yes.
also read over.
yes.
We have said, what is the eligibility certificate issued under the disability rules,
Yes.
2017. So now, the page 44, my lord, this is the general guidelines at the time of.
They'll get them not work out, especially it is mentioned for this purpose.
Now, my lord, page 44, general instructions. So at the time of applying, they have to satisfy themselves. We will see it, my lord, at the last stage. All applicants must fulfill essential requirements of the post and other conditions stipulated of the advertisement. They are advised to satisfy themselves before applying. No query asking about advice of the eligibility to entertain. The admission at the all stages of the examination will be purely provisional. Mere issuance of admit card call letter to such candidate will not to imply that has been finally cleared by Wednesday. Now, in the malot, so therefore, at the time of issuance of the malot admit card or allowing him to sit in the exam, we will not see. We will see at the last stage because now malot offer of appointment page 47. Para 5 and para 6. Or para 6 directly, page 47. Further, the appointment is subject to production of certificate, medical fitness certificate from the medical officer ONGC clinic. So and so, and goes 100 rupees, non-judicial stamp paper, he has to give one bond. Now, this medical authority, while going for medical examination by doctors, they found this impairment. So our assessment, he is temporary. And his certificate is also, he is temporary. This is our difficulty. Now, my lord, one submission, just 1 month. My lord, here, he made a request before the authority.
Yes, I mean.
In our affidavit, my lord, we filed on 7/3/2024. Annexure A, page 10. Page 10, my lord. Oh, running page, my lord. Affidavit filed on 7th. Oh,
কোন তাৰিখৰ তোমাৰ?
my lord, file on additional affidavit I filed, my lord.
এইটো কিমান আছে পেজটো মই কৈ দিব পাৰিম।
Prabhakar Kumar has filed. Additional affidavit.
নাই মইতো পেজিং কৰা নাই এইটো।
Yes.
Well, he submitted the email before the authority saying that with reference to page 10 of that affidavit, my lord, annexure A, with reference to an email dated 2/6/2020 and my previous mail dated so and so. I hereby beg to state I have already applied for permanent disability certificate at Zohat.
Hmm.
Doctor Health Service Sipsaga, and they will arrange medical board in between 12/6/2023 to 15/6/2023, subject to the availability of the medical board members, doctors in same and chairman. Already I went to Guwahati Medical College Hospital on 9/6/2023 for some medical tests. I have gone to Johat Medical College Hospital today for some other medical tests and required for issuance of permanent disability certificate, and the process is going on. So I request you, your kind authority to give time up to 29/6/2020, enable me to submit the permanent disability certificate. So for the requirement is concerned permanent, he knows. And we given him time a lot in the writ petition, page 63. On the basis of his application, that he will obtain a permanent certificate, he knows that that being the temporary, that will not do. So one person at the same time, my lord, perhaps cannot approve a reprobate, my lord, at the same time. Page 63, just one second. This is our reply to his email that just now I read, second para. As communicated by mail dated 2/6/2020, you are again request to produce permanent certificate as per guideline on the subject in prescribed format on permanent disability latest by 29/6/2023. This is the date to which date he requested. So, so far this certificate is concerned requirement is everything was made known to him and he knows that, my lord.
I'll come on that.
So these are my
Here
submissions.
the question, my lord. Then what I'll do as a layman and what I need of this one, that is why even I have not suppressed the material facts regarding this. In my writ petition, I have clearly stated. Thereafter, when they have insisted me, go for permanent, I was not knowing. Reason I do not know. I thought they may give me. The reason I have told, okay, I'll try. They are insisting me, you give me permanent certificate. That the layman, what he knows. He told, okay, I'll go for permanent certificate. That's why I have stated, I am not a this one. Thereafter, petitioner has here, when they have insisted me, I have stated in paragraph 12, page 18. Thereafter, petitioner approached the chairman of District Disability Board Sipsagar to issue permanent disability certificate, but the chairman of the medical board declined to permanent disability certificate. There is no provision of this one. There is no provision. I have stated this one. I have not suppressed also. This is clearly mentioned. And when, in spite of that, they wanted to cancel, they are going to ultimatum they have given. Then, being helpless, I approached our honorable court. Our very first day, considering the beneficiary case and balance of our petitioner, then it has been one post is kept vacant, Miller. That is my submission. It is not, we are not suppressing. We cannot give Miller, because to survive, if I say, okay, I will not bring permanent certificate, whatever you do, my on the spot, they will cancel my decision. I have to survive. Then I have to say that, okay, okay, let me try, because I do not know provision. Then I approached also. This one I have stated. In oath, I have submitted, Miller, before your lordship. I have not suppressed the material fact. That is my humble submission. And after going to your lordship, I have my humble last prayer is before lordship. Question of precedence or the future will come, because I am suffering, Miller. Let them give, whenever they are giving advertisement, let them give, they will not, there's no hamper of this one. They let them give whatever insufficiency or whatever defect is, they let them clear. Let me, because allow you to work up to this one, your lordship is inclined to do this one. This is my humble submission, Miller. I'm doing to your lordship now.
Heard Mr.
Tiburu,
Silbaro.
repetition.
Then I'll come to the petition. Also heard Mr. BK Das. Then so you are the standing counsel. 1 to 4. Then the standing counsel of NGC.
And-
For the respondents, 1 to 4.
Mr. That he was available. I'll tell him.
Is
to-
it N over U?
Upamanyu.
Upa-
D,
Upamanyu?
D Upamanyu, then the standing council health
D.
department,
Govind. Okay.
for there is one number 5.
Five.
Stop. But the petitioner is suffering from 55% disability within bracket hearing impairment. And to that effect, a temporary disability certificate was issued by the medical authority, Sivasagar, Assam, on 25/5/2022. The validity of the said disability, the said temporary disability certificate,
Up to 25/10,
up to
2025.
25/10,
2025.
But pursuant to an advertisement notice what date is this?
And that was, Harshant, that was,
7/5/2022, page 31. Advertisement number is there, 2 of 2022.
Okay, then just a pursuant to an advertisement number 2/2022
advertisement 2022, in bracket RNP.
within bracket R and B
Right to the-
issued by the Oil and Natural Gas Corporation Limited within bracket ONGC for appointment of non-executives. The petitioner applied for the post of junior technician
Diesel, in bracket.
within bracket diesel for the in respect of zone 9, isn't it?
Yes, Zone, Assam,
In respect of zone 9,
Zone 9.
June, page 36,
That is for ONG work center in Assam,
Center in Assam.
Assam,
for in respect of ONGC work center
Assam.
in Assam.
There is a 9 post total,
Stop.
advertise.
Scale number 15.
Out of the 9 posts of junior technician diesel, 2 posts were reserved
For
for
category B, in bracket DHH. Lordship will get in category, what category? B.
for category B
B,
within bracket D, comma HH.
HS.
Close bracket. The petitioner thereafter participated in the recruitment process. And where is the selection?
Selection.
Select list.
Lordship. I'll give you. There you go. Head. Submission of online was, let me record it, 27/5/2020, 25/2022, my lord. Dated. And there is a clause also, may Lordship, 41, the same advertisement.
Thereafter.
Because one
Mr.
clause is their criteria.
Participated in the selection process and was selected
Date of interview was on 10/8/2022.
accordingly.
Acha.
The ONGC issued the offer of employment dated 6/5/2023,
18.
16/5/2023 to the petitioner. Stop. Clause 6 of the offer of appointment dated 16/5/2023 provides that the appointment is subject to the production of certificate of medical and physical fitness from the medical officer of ONGC clinic/hospital. Stop. The grievance of the petitioner. No. Draft. The petitioner subjected himself to the medical test and with regard to his disability, the where's that thing?
Page 58.
The medical officer, ONGC, found the petitioner
Left ear impaired.
found that the disability with regard to his left ear as impaired and the right and left ear as defective, correct?
Mat.
Stop. The grievance of the petitioner is that despite his temporary disability certificate issued by the competent authority, the ONGC authorities are refusing him to give appointment to the post of junior assistant, junior technician,
Technical DJ.
junior technician within bracket diesel, on the ground that the disability certificate of the petitioner is only temporary and not permanent. Stop. Being aggrieved, accordingly, the present writ petition has been filed. Stop. Mr. C. Barwal and the counsel for the petitioner submits that as the temporary disability certificate of the petitioner has been issued by the competent authority as prescribed under the Rights of Persons with Disabilities Act 2016, within bracket Act of 2016 in short, as well as the Rights of Persons
With disabilities.
with Disabilities Rules 2017, within bracket Rules of 2017 in short, the ONGC authorities would not have refused appointment to the petitioner, particularly when he has successfully completed the recruitment process. Stop. He therefore submits that the direction should be issued to the respondents, particularly the respondents 1 to 4, to issue appointment order to the petitioner in as much as he has successfully completed the recruitment process. That's basically your case.
Yes.
Mr. BK Das, then as counsel for the respondents 1 to 4. On the other hand, submits that as the petitioner is having only a temporary disability certificate, the authorities, the ONGC authorities are not in a position to give him appointment in as much as the in as much as a permanent disability certificate is required for his appointment.
In
Stop.
view of, in view of definition, section 2S.
In view of the, in view of section two
S of the,
S
of the act,
of the Act of 2016.
which
Stop.
means long-term disability.
He submits the section two within bracket S means a person with long-term physical, mental, intellectual or sensory impairment. And as the petitioner is only having a temporary disability certificate
Only in respect of 1 year.
only
Left
in
ear.
respect of 1 year. Only in respect of the left ear.
Left.
The respondents are not in a position to give temporary, to give appointment to the petitioner. Stop. He also submits if in the event that this court gives a direction for appointment to the petitioner, it would set a bad precedence in future. Stop. He therefore submits that the predominant petition should be dismissed. Para Mr. N. Obamania, D. Obamania Leonard, Standing Council Health Department submits that 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 in terms of the notification dated 30/10/2019 2009 issued by the Ministry of Social Justice and Empowerment, which clearly states that the permanent disability certificate can only be issued in cases where there are no chances of variation, over time, in the degree of disability, and in case where there is any chance of variation, over time, in the degree of disability, the period of validity in the certificate should have to be indicated. Stop. As the case of the petitioner was found to have chances of variation, he was issued the temporary temporary disability certificate, which is valid up to 25/10/2025. Stop. After expiry of the validity period, the petitioner would have to apply through online as per the guidelines. And thereafter, he will have to appear before the competent board for proper assessment, and the board will decide for issuance of permanent certificate accordingly. Stop. But after hearing the learned counsel for the parties, no, I've heard the learned counsel for the parties. Stop. But the advertisement issued by the ONGC for filling up of, is it non-executive post?
Yes.
No, non-executive.
Correct,
Yes.
for filling up
Very-
of non-executive.
Very head itself it is there, non-executive.
Provides for 9 posts of junior technicians within bracket diesel
Or some job.
with in respect of ONGC work center in Assam. Stop. From the 9 posts of junior assistant technician diesel, 2 posts are reserved for category B. No. 2 posts are reserved for benchmark disabilities.
Okay, very
categories.
okay.
Stop. Further, comma, clause G, within bracket, Roman 18, provides that the certificate of disability should be issued by the notified medical authority in the format prescribed in the Rights of Person with Disability Rules 2017 and the minimum degree of disability for a person to be eligible for any concession oblique benefits would be 40%. Para. Rule 18, within bracket 3, within bracket 2, within bracket Roman 2 of the rules of 2017 prescribes that the medical authority, after due consideration, after due examination, no, don't say like that. After due consideration, shall issue a certificate of disability indicating the period of disability in cases where there is any chance of variation over time in the degree of disability. Stop. Further, comma, Rule 19 of the rules of 2017 provides that a person to whom the certificate issued under Rule 18 shall be entitled to apply for facilities, comma, concessions, and benefits admissible for persons with disabilities under schemes of the government and of non-governmental organizations funded by the government. Stop. But in the present case in hand, comma, it is undisputed that the temporary disability certificate issued to the petitioner, which is valid
25/10/24.
up to 25/10/2025, has been issued by the competent board. Stop. Para, by the competent board. Stop. This court has also considered the medical report of the petitioner made by the medical officer of ONGC. In the report, it is also clearly stated that there is impairment in the right ear and both the left, there's impairment in the left ear and both the right ears and left ears are defective. Considering that, para, the petitioner is holding a temporary disability certificate, comma, this court does not see any reason as to why the ONGC authorities should refrain from giving appointment to the petitioner only on the ground that he is holding a temporary disability certificate, and more particularly when he has successfully passed the recruitment process. Stop. Para. After examining the balance of convenience and in the interest of justice, the ONGC authorities are directed to issue appointment order to the petitioner to the post of junior technician
In bracket detail.
bracket diesel under the disability category up to the validity up to 25/10/2025, i.e. the date of validity of the temporary disability certificate of the petition. Stop. This court makes it clear that this shall not be a precedent for in future for other cases. Stop. It is further made clear that after the expiry of the validity period of the temporary disability certificate of the petitioner, comma, he shall undergo the required medical test before the competent board. And if he is found that his degree of disability has gone down below the benchmark of 40%.
Yeah.
Comma, the ONGC authorities are given liberty to terminate the service of the petitioner without any notice. Stop. However, in the event that he is found to be having a permanent disability, he shall be allowed to continue. Stop. Any other conditions you want?
It will do, man.
Hmm?
Procedure is taken care.
Yes. With the above observations and directions, this recommendation is disposed of.
Only
Obliged.
prayer. Only last prayer, Miller, for the satisfaction. Some time frame may be given, otherwise, so that let them join within 1 week, 2 weeks or what.
And that processing period is.
At least
it has
time frame may be framed, Miller,
This made clear that the ONGC authorities
within 15 days or.
No. Look, it has to be cleared from the head office Dehradun, Malo. So sometime.
1 month, Miller.
60, to 2 months time.
2 months.
He has
is
waited so
that
much.
the appointment of the petitioner should be given to the
45 days, Miller,
within a
concession.
period of- At the earliest, but not later than 2 months from today.
That
Oh, like-
notification, Lordship, that is 30/12/2009, Lordship, not 30/10/2000. That's
Which one?
notification. Notification of the Ministry of Justice, Social Justice. It is 30/12, Lordship, 2009. 12, Lordship.
Interim order is,
30
was there,
days.
Miller, that is to be also looked into.
30/10,
Is also not available to.
page 81, Lordship.
2009.
Babu,
Also 30/12.
yes, obliged.
Highly obliged, Lordship.
My lord, interim order should be merged with
Oh.
final order.
Interim order stands merged with this
Fine.
final order. Give him that book, keep this book. One, she may record.
Item 12.
In this
case, Lordship, we are affidavit in opposition is ready to be filed in a day or two. Let it be taken up on 30th of April, Lordship.
30 will not be here, you know. 30 will be difficult for us a lot. Different date.
Okay, heard, Mr.
AM doctor.
AM Datta, Learned Counsel for the review petition. Mr. Ardhar, Learned Counsel, appearing for the sole respondent, submits that the affidavit in opposition is ready and will be filed within the period of 1 week from today. Stop. Accordingly, list this matter on, when do you want, in May?
May is
Second? Second,
Seventh. May.
7 day holiday, your lord.
Oh, seventh is the holiday.
Or 21, your lord. 21st of May.
Friday, Lordship, let it be an hearing, your Lordship. Let it be on
21st of
11th of, sorry,
21st of May. 21st of May, your lord. Hearing this.
public.
Must.
13.
Is a lordship. Lordship here, this contempt, the subject matter of this contempt also connected with the subject matter of WPC 3562 oblique 2022. Lordship, so my prayer, Lordship, today, these two matters may be tagged to be directed to be placed in the next week or
No. This contempt is arising out of WBC.
the 3525.
Oh.
Wherein a direction was there to consider that is lordship that is page 11 para 5. As regards the other prayers of WPC 352 for the back wages from 21/6/2001 to 29/7/2008, as well as for the area salaries from year 1992, we require petitioner to file a representation claiming claiming in detail the factual basis as well as the law under which the area salaries are claimed, and the representation be given due consideration by the Chief Regional Manager, Oriental Insurance Company Limited, within a period of 1 month from the representation being submitted. So that was the direction, Lordship. And way back, and in terms of this order,
Have you made your representation?
yes, Lordship, that was made on 9/3 because the calculation book was holding by the general manager, so that some time taken for that. So 9/3/2000, this 2023 representation being submitted along with the calculation, Lordship. This also, we are also enclosing the page 13.
Where's the representation?
That page starts from page 12. An explanation also given, Lordship, why delay in filing the representation. May I read the contents, Lordship? Page 12. With due respect, I would like to state that the Honorable High Court, by the order dated 12/12/2022, passed in WPC, wherein Honorable High Court directed to consider my said representation for back wages from 21/6/2001 to 27/7/2008, as well as the area salary from 1992. In this connection, I am enclosing here with my statement of back wages from June 2001. Moreover, I would also request to consider the area revision pay scale from 1997 up to 2007. It is pertinent to state that the statement of revisions are in your custody. As such, there is a delay in filing the representation, and this is supported by the.
This has not been considered.
This has not been considered yet. That is why Lordship, now she is at the age of superannuation. Within 6 months, she is going to retire from her service. That is why, Lordship, we have filed this. We had no alternative to, because we are filing cases after cases.
Okay. Who is the respondent here?
Yes, so appeared, Lordship, and
Sole respondent. Oh, Datta, you have.
Yes, yes. Lord, first of all, so far, their grievances in regard to payment of arrear salary from, my lord, 2021/6/2001 to 27/7/2008, that we have already paid. And now, so far, other arrear salary from 1992, they are not eligible to get. Apart from that, my lord, this contempt petition is otherwise also not in time. If your lordship look at section 20 of the Contempt of Court Act, is beyond 1 year it has been filed. So on that legal issue itself, the contempt is liable to be dismissed.
But it's read with Article 215.
That's there, my lord, but then the main section is 20. It has to be filed within a period of 1 year. Apart from that, my lord, on merit, but they are saying that my
But
lord,
at least have you replied that the error salaries, they are not eligible to get error salary?
no, I don't think they have replied. Did not get any communication from them.
So that's the only reason. Otherwise, see, you have paid the salary from
Area we have already.
error salary.
No, Lordship, not in terms of the, not in terms of the, what she's supposed to get.
My lord, I am having the workout made by the authority. I believe it is long time back and
That is why if your Lordship club together both the applications, in the meantime, I'll file also a affidavit detailing the, what she has received and what she is supposed to receive. Then it will be,
my lord, what I submit, it cannot be a subject matter of contempt proceeding, my lord. There is no intentional violation because so far the area is concerned, we have already paid. They may say that it's not the sufficient amount. If they want to get more than that, I don't think the department will make such a wrong move. Now, otherwise, my lord, my learned friend has submitted, it may be tagged with the WPC 3562. I believe both the petition may be hard to gather. In any case, it's not a matter of
so
contempt.
Lordship,
proceeding.
after modification, she has been only given 14,435.
No,
Actually,
amount payable 50% of back wages, 2 lakhs 48 something. Less amount paid in excess.
Lordship will,
So you paid a total of 2,27,000.
that is not what I'm supposed to get. That is my contention, Lordship. That is the contention of the petitioner. They have not released what I'm to get, Lordship.
Then let us
So
take up,
this, I think,
Yeah,
they don't
yes.
have any grievance.
yeah. This one you don't have any grievance.
No, Lordship, let us club because they have not acted, Lordship, and time also.
Okay. On request made by MS T. Som, learned counsel for the petitioner. List this matter, list this contempt petition along with WBC number
WPC number 3562
3562
of 2022.
of 2022.
2022.
So, you want to file an affidavit also?
Better we can find.
Mr. S. Datta, learned senior counsel, assisted by Mr. S. Datta, learned counsel, enters appearance on behalf of the sole respondent and prays for
4 weeks.
No, Lordship, that will be again, Lordship. Lordship, may kindly post it in the second week of May. Petitioner also running head to mount condition because of the.
okay, prays for 3 weeks time to file.
Lordship,
I'll try my best.
Please to fix a date, Lordship.
Okay. List on. Sixteenth May.
16th May.
16th, all right.
Deeply obliged.
Obliged.
Deeply obliged.
14 hearing ordered met.
দিন ফিক্স করে দিই না 17 নম্বর my lord, may I pray one thing, my lord? Lordship, fix the matter any other date, my lord. Another matter we have got it, my lord, along with my senior counsel is also there in the respondent. So may I pray some accommodation, my lord? Any day, lordship's convenient.
Yes, Datta.
For me, no problem, my lord. I wanted to finish this, my lord. It's a very old pending matter.
Yes. Okay, on request made by J.R. Babuya, learned counsel for the petitioner. When do you want?
Any day next week, my lord.
Next week.
Convenient to my learned senior, my lord, or any day after.
Put off, you give you a convenient date.
My lord, please.
Any Tuesday, Thursday, my lord. 30th.
20. 29 and 30, my lord, I'll be at Kohima bench. So after that,
We'll do second. Second all right. Second May,
Second,
as a partner.
that's fine.
দাদা, কত নম্বর হলো?
15 part held.
It is, your lordship. This is relating to the dismissal from service, lordship, a disciplinary committee. Disciplinary proceeding was there. They have filed affidavit and we have replied to that also, your lordship. Lordship, the petitioner was serving as police constable, lordship, and FIR was lodged against him regarding, lordship, POCSO Act, lordship. Page 19, annexure 1, lordship.
Yes.
With due respect, it is stated that on last 27/7/19 in the morning about so the below mentioned accused called my sister-in-law Tara Banu, 11 years, in his house for cleaning utensils and by closing the door forcibly raped her. It is therefore prayed to your honor to investigate the matter. So lordship accordingly received and registered by Bongaigaon PS case number so and so under section 4 of POCSO Act 2012. Lordship. And accordingly, he was arrested. Annexure 2, page 23 is his suspension order, lordship. Page 23. Lordship. He was placed under suspension after arrest, lordship. Pending departmental inquiry against him. That their lordship, first Shoko's notice was sent on 13/11/2019, page 24, annexure 3, Lord. Second paragraph, lordship, that while you were posted at Biddapur OP NRC duty, lordship, on 31/7/2019, complainant Musammad Sahida Khatun, wife of so and so, lodged an FIR to the effect that you called your her niece, namely Tara Banu, aged about 11 years, to your house on the pretext of washing utensils and forcibly committed rape on her. The victim, along with her brother and sister-in-law, resides in your rented house. In this regard, a case has been registered for your involvement by Bongaigaon PS case number so and so. This tantamounts to your gross immoral conduct, indiscipline act, and dereliction of duty on your part as a member of disciplined police force. Therefore, you are charged with gross immoral conduct, indiscipline act, and dereliction of duty. The list of documents and witnesses proposed to be relied upon for proving these charges and allegations are also enclosed herewith. You should submit your written statement in defense within 10 days from the date of receipt of this communication, provided you do not intend to inspect the documents which have relevance with the issue under inquiry. In case you intend to inspect those documents, you should write to the undersigned for the same within 7 days from the date of receipt of this communication and submit your explanation thereafter within 10 days from the date of completion of the inspection. Your written statement stating whether you desire to be heard in person should be submitted to the undersigned within the period specified above. If the disciplinary authority decides to appoint an inquiry officer to inquire into the charges, you will be allowed to represent your case if you so desire with the assistance of any other government servant approved by the disciplinary authority, but you will not be allowed to engage a legal practitioner for the purpose unless the person nominated by the disciplinary authority to present the case in support of the charges before the inquiry authority is a legal practitioner or unless disciplinary authority so permits. Thereafter, these are list of documents and list of PW's, lordship. Then statement of allegation, page 26, same as the FIR, lordship. Now my reply, page 27, annexure 4. That was not so satisfactory, your lordship. A simple reply was given by the petitioner. With due respect and humble submission, I beg to state that the allegation against me is totally false and fabricated and which is imaginary in nature. It is true that one Musammad Sahida Khatun, wife of Mohammad Keramat Ali of Dolaigao, Ujanpara, lodged an FIR to the effect that I called Tara Banu, aged about 11 years, to my house for working utensils and forcefully committed rape on her. Subsequently, a case was registered against me. It is mentioned here that the whole story of the FIR is totally false and fabricated, and I am completely innocent for alleged offense and made against me. And therefore, the Shawkos letter served upon me is liable to be dismissed and thereby released from all the charges framed upon me. That was the first Shawkos reply of the petitioner, Lordship. Then the inquiry was held, Lordship, after changing of some inquiry officers. Finally, Srimati Luna Sonowal, APS inquiry officer, submitted her reply, Lordship, inquiry report. That is Annexure 5, page 28, Lordship. Last paragraph, Lordship. Accordingly, the first shock was noticed. I am reading from that part, Lordship. Accordingly, the first shock was noticed under Section 65 of Assam Police Act 2007, read with Rule 66 of the Assam Police Manual, Part 3, Article 311 of the Constitution of India, and Rule 7 of Assam Services Discipline and Appeal Rules 1964 was issued and served to the delinquent by memo number so-and-so. He submitted his first show cause reply on 25/11/2019. The disciplinary authority, after perusing the written explanation of the delinquent, was not satisfied and appointed Sri Makhan Bora, APS, the then Deputy Inspector of Police, Border Bongaigaon, as inquiry officer by memo number so-and-so. Then the DP file was endorsed to Sri Pankaj Kakoti, APS, the then additional SP headquarter, Bongaigaon, as inquiry officer, but after district transfer of the earlier inquiry officer, Sri Makhan Bora, APS, by number so-and-so, dated 13/3/2020. Hardly the DP file number so-and-so was endorsed to me as inquiry officer to inquire into the allegation by memo number so-and-so. And accordingly, I had received the DP file number so-and-so containing from page number 1 to page number 30, along with note sheet, page number 1 to 5, and other relevant documents on 7/10/2021 from the Reserve Officer, Police Reserve Bongaigaon, by so-and-so, to commence the inquiry. During my inquiry, I have examined the listed prosecution witnesses and their statements were recorded. Accordingly, during examination of the prosecution witnesses, I offered them to examine the copies of relevant documents to refresh their memories and confirm accuracy, veracity, and authenticity. The delinquent was also given a chance to adduce defense witnesses, if any, but the delinquent denied. This part, Lordship, I am denying, as because, Lordship, the witnesses were taken behind the back of the petitioner, Lordship. He was never called when the witnesses examined and their statements were recorded, Lordship. I was not given any chance to cross-examine them, Lordship, and I have not furnished any defense witness also, Lordship. I was there, I was asked to put my signatures in the documents, whatever documents they provided, I have signed, Lordship. The statement of prosecution witnesses, namely Inspector UB Jyoti Lahan, the then OC Bongaigaon PS, UB Monindra Narayan Das, the then in charge North Bongaigaon PP, now Inspector, so in CID Guwahati, and the Sri Dewan Hormuz Ali, the then in charge of Bidyapur OP, now retired from service. 4, complainant Musammad Sahida Khatun, wife of Mohammad Keramat Ali, village Dolaigao, Ujanpara, PS so, Miss Tara Banu, niece of complainant Shahida Khatun. 6, charge officer Abdul Razzaq Mondal of this Lordship Departmental Inquiry proceeding. PW1 Sri Jyoti Lahan, the then OC Bongaigaon PS, his statement, Lordship. He stated that last on 31/7/2019, while he was posted as OC Bongaigaon PS, the complainant Musammad Sahida Khatun, wife of so-and-so, lodged written an FIR at North Bongaigaon PP and stating that last on so-and-so at about 8 AM, the accused person, namely Abdul Razzaq Mondal, so-and-so, called her niece, Miss Tara Banu, aged about 11 years, to his house and shut the door in the pretext of washing utensils and forcibly committed rape on her. At that time, SI UB Shopan Kumar Roy, temporary officer in charge of Bongaigaon PS, received the Ejahar and registered a case by Bongaigaon PS case number so and so. The case was endorsed to SI UB Monindra Narayan Das, the then in charge of North Bongaigaon PP, for investigation. During investigation, accused Abdul Razzaq Mandal was arrested and forwarded to judicial custody. In this regard, he has submitted a detailed report to the then SP Bongaigaon. And after completing the investigation of the case, IOSI Monindra Narayan Das has submitted the charge sheet of the case against accused Abdul Razzaq Mandal under Section 4 of POCSO Act. Now, PW2 SI UB Munindra Narayan Das, the then in charge North Bongaigaon PP, now the inspector CID Assam Guwahati. He stated that last on 31/7/2019, he had the then in charge of North Bongaigaon PP. On the same day, complainant Musammad Sahida Khatun, wife of so-and-so lordship of Ujanpara district Bongaigaon, lodged written FIR at North Bongaigaon PP and stated that last on 27/7 at the same allegations lordship. Then he received the Ejahar and was sent to OC Bongaigaon PS for registering the case under proper sections of law. Accordingly, the case was registered at Bongaigaon PS by Bongaigaon PS case number so and so and endorsed to him for investigation, and he completed the investigation. During investigation, found sufficient evidence against accused Abdul Razzaq Mandal and was arrested him and forwarded to judicial custody. Later on, he submitted the charge sheet of the case against accused Abdul Razzaq Mandal under Section 4 of POCSO Act 2012 by Bongaigaon PS case number so and so. PW number 3, SIUB Diwan Hormuz Ali, the then in charge Vidyapur OP, now retired from service. He stated that UBC Abdul Razzaq Mandal was posted at Vidyapur OP and he stayed at Vidyapur OP barrack and was performing NRC duty, but he could not remember the date. The then Superintendent of Police Bongaigaon and the then Additional SP Headquarters Bongaigaon asked him over telephone about the UBC 163 Abdul Razzaq Mandal was present at Vidyapur OP. Thereafter, he checked at barrack but did not find UBC Abdul Razzaq Mandal and accordingly informed to the then SP Bongaigaon. Later, about 20-25 minutes, the then Additional SP Headquarters Bongaigaon informed him again over telephone that UBC Abdul Razzaq Mandal presently stayed at Kokrajhar district under Fakiragram PS and asked him to go to Fakiragram PS with the OP vehicle along with armed force and report to the OC Fakiragram PS. He went to Fakiragram PS along with staff and reported OC Fakiragram PS. Accordingly, apprehended UBC Abdul Razzaq Mandal at Kao Bazar under Fakiragram PS and brought him to Bongaigaon PS and handed over at Bongaigaon PS. He stated that an absent report against UBC Abdul Razzaq Mandal was already sent to SP Bongaigaon by WT message. So this is the statement of Hormuz Ali lordship, who arrested the petitioner lordship. PW4 is the complainant Musammad Sahida Khatun. She stated that last on 27/7/2019 at about 8 AM, UBC Abdul Razzaq Mandal called her niece. The same allegations lordship. After 2-3 days, Ms. Tara Banu informed her about the incident. Then after on 31/7/2021, the incident happened. She has lodged an FIR at North Bongaigaon PP regarding the same. During the incident, Ms. Tara Banu, victim, her niece was 11 years on 27/7/19. Her statement is in sign with the complainant she filed earlier. PW5, Ms. Tara Banu. Lordship, may add to Lordship. PW5, page 31.
Yes.
She is the victim lordship. She stated that last on 27/7/2019, she went to her brother's rented house who was staying in the rented house within the premises of the Abdul Razzaq Mondal's house. On the same day, UBC Abdul Razzaq Mondal called her to work in his house and forcibly committed rape on her. The victim did not inform about the incident immediately, but after 2 days, she told the entire incident to Musammad Sahida Khatun, and the latter lodged an FIR at North Bongaigaon. PW6 is the charged officer, Lordship. He stated that he was performing duty at Bongaigaon DEF during incident he had posted at Vidyapur OP. He was deputed to perform NRC duty at Vidyapur Gaon Panchayat office. After completion of NRC duty daily, he has stayed at Vidyapur OP. One HG also was deputed along with him to perform NRC duty with him. Last on 31/7/2019, after completion of NRC duty, he went to Fakiragram Bazar to purchase cow. The OC Fakiragram PS along with in-charge Vidyapur OP met him at Cow Bazar Fakiragram and brought him to Bongaigaon PS and handed over at PS as ordered by the additional SP Bongaigaon. He knows that one, namely Umar Ali, lodged an FIR at Bongaigaon PS against him. He stated that few days prior to the incident, a verbal argument took place between him and Umar Ali due to non-receipt of house rent of his rented house and threatened him. Then after he was arrested and forwarded to judicial custody. It is to be mentioned here that the above statement of UBC Abdul Razzaq Mondal was made in his defense as a charged person in connection with DP number so-and-so. Further, during the course of inquiry, the delinquent was given adequate chances to engage defense witness or evidence, but he declined to do so in this regard. Here, Lordship, the inquiry officer, page 29, stated in second paragraph that during my inquiry, I have examined the listed prosecution witnesses. She has examined and their statements were recorded accordingly. During examination of the prosecution witnesses, I offered them to examine the copies of relevant documents to refresh their memories and confirm accuracy, veracity, and authenticity.
You are reading from?
Page 29, Lordship, second paragraph. Second page of this inquiry report, Lordship. During my inquiry. Earlier, Lordship, the inquiry officers, some other inquiry officers were there. This Luna Sonwal was lastly handed over the inquiry and she has, Lordship, submitted this report. So she written that during my inquiry, I have examined the listed prosecution witnesses and their statements were recorded accordingly. During examination of the prosecution witnesses, I offered them to examine the copies of relevant documents to refresh their memories and confirm accuracy, veracity, and authenticity. The delinquent was also given a chance to adduce defense witnesses, if any, but the delinquent denied. But Lordship, in this inquiry report, in the later part, after this primary exhibits and secondary exhibits, conclusion and findings part, Lordship, that is page 33, Lordship.
Yes.
Paragraph 6, further it is seen through the progress of the DP that the charged personnel have not cooperated with the investigating and senior officers. He was absent from his duty post and hide his whereabouts. Further, UBC Abdul Razzaq Mondal was released from judicial custody on bail and revoked from suspension. Currently, he is deputed to the office of the Inspector General of Police so-and-so and for performing duty with the IGP WR Assam Bongaigaon. During inquiry, the charged person was given chances for cross-examination, but he has nothing to say as he had already given his statement to the previous inquiry officer. But here she has written that she herself taken statement of all the witnesses and the delinquent also. The delinquent was also given a chance to adduce defense witnesses, if any, but the delinquent denied, Lordship. So, Lordship, she has not taken the statement of the charged officer, and whether she has taken the statement of all the witnesses in the presence of the delinquent, that was also not mentioned. Simply writing that I have given chance to the delinquent to cross-examine will all the witnesses. But as per the version of the petitioner lordship, he has never seen the witnesses in his front lordship. He was only asked to put some signatures in some documents, and they are his lordship officials, employers. So he was only putting his signatures in those documents, lordship. There was never any chance given to the delinquent to adduce any evidence, and neither he was allowed to cross-examine those witnesses, lordship. And he, lordship, orally asked that I may be allowed to bring someone along with me, as I am not aware about all the written procedures, lordship. I am simply a constable. That was negated, lordship. And it was in the show cause notice itself written that if he wants an assistance of an advocate, that will not be given to him. Only a government official can be permitted, but he has not written any letter to the lordship accommodate any personnel from the official, or though that lordship, that proof is not with the petitioner, but only the thing that he orally submitted that I may be allowed to accompany some official or an advocate, lordship. That was negated by the inquiry officer and all the inquiry officers, lordship. And so, lordship, the second show cause notice was served upon him, page 34, on 11/6/2022. Same allegations as per the inquiry of his inquiry report and as per the first show cause notice. Last para only, lordship. Under the above facts and circumstances, I concur with the findings of the inquiry officer, whereas I, being a disciplinary authority, is contemplating to lordship, some major punishment upon the charged officer for his gross immoral conduct in disciplinary act and dereliction of duty as a member of the disciplinary police force. I hereby give a final opportunity to the charged officer to raise any objection, submission, personal hearing. If desires, he may approach the undersigned in writing within 15 days from the date of receipt of this communication. Then the reply was given by the charged officer. That is annexure 8, page 39. Before that, lordship, the medical report of the victim I have annexed along with this petition as annexure 7, lordship, page 36. Your lordship may kindly go through that. Though there was no injury report, nothing in this medical report, lordship, only taking the benefit of this second paragraph findings, lordship, the appellate authority did not consider his appeal, lordship. So, lordship, my reply is page 39, annexure 8, lordship. With due respect and humble submission, I beg to state that in connection with aforesaid DP byte number so-and-so, the inquiry officer conducted her inquiry after going through the procedure and recorded statements of witnesses and collected materials in connection with the DP. During the inquiry officer recorded the statements of Inspector Jyoti Lahan, the then officer in charge, Bongaigaon Police Station, Munindra Narayan Das. Both of them stated about the alleged offense against me by the complainant Shahida Khatun, and in connection with the said complaint, a case was registered so-and-so, and the same was endorsed to SI Munindra Narayan Das for investigation of aforesaid case. During investigation, the investigation officer arrested me and forwards me to judicial custody. And after going through the investigation, he submitted charge sheet against me by charge sheet number so-and-so. In the meantime, I granted bail from the Honorable Guwahati High Court, and now I am facing the trial of the instant case. During trial, the victim, complainant, and other witnesses had already examined by the Honorable Special Judge Bongaigaon. The doctor who examined the victim at the time had already examined by the Honorable Special Judge Bongaigaon, and she found no injury mark on the private part of the victim and hymen of the victim found intact. It is further mentioned here that the medical evidence of this case ruled out the ocular testimony of the victim. So there is every possibility of acquittal in the aforesaid case in my favor, as the said case is concocted and manipulated case. The testimony of the victim and the doctor who conducted her medical examination before the Honorable Special Judge Bongaigaon are enclosed herewith for your kind perusal. The complainant and the victim of the aforesaid case obviously stated as per their case, and in this proceeding also just to harass me. So the alleged charges against me for negligence, dereliction of duty, and gross misconduct on my part are totally unacceptable and baseless allegation without any rhyme and reason. I perform my duty as a member of disciplined police force and obey all the order and also follow the rules. So from the above facts and circumstances, it is therefore prayed that the Shoko's letter served upon me is liable to be dismissed and thereby released from all the charges framed upon me. So, Lordship, the first Shoko's reply, in fact, it was not so, Lordship, goodly handled, but the second reply, Lordship, he has furnished every detail of the trial also, that there was no medical injury on the victim, Lordship. After, in spite of all, Lordship, the final order was given dismissing the petitioner from service on 4th July 2022. That is page 42, Lordship. And page 43, paragraph 4, your Lordship will find. On earlier occasion, I have argued one point that the presenting officer was witness, Lordship.
Where's the?
That is in page 43, paragraph 4, Lordship. Thereafter, the DP was re-endorsed to Sri Pankaj Kumar Kakoti APS, the then additional SP headquarter Bongaigaon, by this office memo number so-and-so, dated so-and-so. The inquiry officer recorded the statements of prosecuting witnesses, namely Inspector Jyoti Lahan, Monindra Das, Diwan Hormuz Ali. Number 4 is the person Satyanath Kalita, Lordship. He was the presenting officer.
How do we know that?
Page 43, witness number 4, Satyanath Kalita, Lordship.
Where's the order appointing the presenting officer?
Lordship.
Where's the order appointing the presenting officer?
Lordship, that is inquiry officer. Later on, Luna Sonowal came to the as a third inquiry officer, third or fourth, Lordship. She submitted the inquiry reports. But Lordship, this Satyanath Kalita was presenting officer. Page 41. He was presenting officer in the first Shoko's notice. I have seen his name, page 25, Lordship. Page 25, last part, Lordship, presenting officer Satyanath Kalita, Lordship. So as per this order, Lordship, he was the witness. As per page 43, he was witness, Satyanath Kalita was a witness. So that is my one of argument that presenting officer cannot be a witness, Lordship, in the proceeding. So after this, Lordship, page 44, last part, accordingly, UBC 163 Abdur Razzaq Mandal stands dismissed from service with immediate effect as per Rule 7 of the Assam Service Discipline Appeal Rules 1964 for his gross immoral conduct, indiscipline act, and dereliction of duty. Thereafter, we preferred an appeal, page 45, that is an appeal under Rule 66B of the Assam Police Manual. Lordship. When my appeal was not considered within a period of 1 month, I preferred a writ petition before this Honorable High Court. Lordship. That is page 54, Annexure 11, WPC number 5786 of 2022, Lordship. This court by the order dated 5/9/22 directed, page 56 is the relevant portion. In view of the consent of the parties, the appellate authority, that is the respondent number 3, is directed to take a decision on the petitioner's appeal dated 22/7/2022 within a period of 1 month from the date of receipt of a certified copy of this order. Accordingly, his appeal was disposed of by the order dated 7/10/2022, page 57, Annexure 12. Against this order, Lordship, this present writ petition was filed.
What are your grounds?
So my submission before your Lordship, I have cited some decisions on last occasion before your Lordship. One is, Lordship, in 1958, AIR 1958 SC, page 86, para 7. In that case, Lordship, presiding officer was himself giving evidence, Lordship. Para 7, Lordship. Para 7, page 4.
Yes.
I have taken a stand that, Lordship, the presenting officer Satyanath Kalita, he cannot be a witness, Lordship, in this case. Accordingly, this decision says, para 7, it will be recalled that the forged letter of December so was suspected to have been manufactured or sent by or at the instance of the respondent to further his interest. The case against the respondent was that the offending letter had been typed by one Sariful Hassan, the typist, attached to the office of the Superintendent of Police, Fatehpur, and therefore it was essential for the department to establish that the respondent was in friendly relations with Sariful Hassan, who was said to have typed the letter. Apparently, in some preliminary inquiry and in the presence of Sri B.N. Bhalla, this B.N. Bhalla became a witness later on. One Muhammad Khalil, a head constable, had spoken about Sariful Hassan being very friendly with the respondent. But while giving his evidence at the departmental trial, the said Muhammad Khalil denied having made any such statement. In the circumstances, it became necessary to contradict him by the testimony of Sri B.N. Bhalla, in whose presence that witness had on a previous occasion stated that Sariful Hassan was very friendly with the respondent. Accordingly, Sri B.N. Bhalla had his testimony recorded by a Deputy Superintendent of Police. This was done at 2 stages, namely once before the charges were framed and again after the framing of the charges. The respondent's grievance is that Sri B.N. Bhalla, who had thus become a witness in the case, ought not to have further continued to act as the presiding officer, and that is continuing to do so vitiated the trial and his order was a nullity. That Sri B.N. Bhalla had his own testimony recorded in the case is not denied. Indeed, the appellant state in opposition to the, thereafter these are discussions, Lordship. Then the third paragraph, the salient facts being thus admitted, there can be no escape from the conclusion that Sri B.N. Bhalla should not have presided over the trial any longer. The point in issue was whether Sariful Hassan was in friendly relationship with the respondent. Muhammad Khalil had in his evidence at the trial denied having made any statement to this effect. Said B.N. Bhalla gave evidence that Muhammad Khalil had in his presence admitted this friendship of Sariful Hassan with the respondent. Which of the two witnesses, Muhammad Khalil and Sri B.N. Bhalla, was to be believed was the duty of the person presiding over the trial to determine. Sri B.N. Bhalla was obviously most ill-suited to undertake that task. Having pitted his evidence against that of Muhammad Khalil, Sri B.N. Bhalla vacated the judge's seat and entered the arena as a witness. The two roles could not obviously be played by one and the same person. Indeed, Sri B.N. Balla himself realized it and accordingly had his own evidence recorded on both the occasions by other high officers. It is futile to expect that he could, in the circumstances, hold the scale even. It is suggested that there might have been other evidence establishing the friendship between the Sariful Hassan and the respondent, and that the evidence of Sri B.N. Balla might not have been relied on or might not have been the deciding factor. There is nothing on the record before us to support this suggestion. But assuming that Sri B.N. Balla did not rely on his own evidence in preference to that of Muhammad Khalil, a fact which is hard to believe, especially in the face of his own affidavit quoted above, the act of Sri B.N. Balla in having his own testimony recorded in the case undoubtedly evidences a state of mind which clearly discloses considerable bias against the respondent. If it shocks our notions of judicial propriety and fair play, as indeed it does, it was bound to make a deeper impression on the mind of the respondent as to the unreality and futility of the proceedings conducted in this fashion. We find ourselves in agreement with the High Court that the rules of natural justice were completely discarded and all canons of fair play were grievously violated by Sri B.N. Balla continuing to preside over the trial. Decisions arrived at by such process and order founded on such decision cannot possibly be regarded as valid or binding. So in this case also, even if Satyanath Kalita was not taken as a witness in the inquiry report, Lordship, earlier he was a witness and the presenting officer, he himself became witness in the proceeding, Lordship. So natural justice was violated, Lordship. And next one is Lordship 2004-3 GLR 372, Lordship. And there also, Lordship, paragraph 12. Paragraph 12, page 9, Lordship. It is a case in which the same very disciplinary authority which had issued the charge sheet against the petitioner became the witness in support of the charges. It is in this connection the aforesaid cases have been referred to by the learned counsel for the petitioner. In the case of Muhammad Noor Supra, the apex court, after noticing that the presiding officer in a departmental trial had given his own testimony against the delinquent, held that the same undoubtedly evidenced a state of mind clearly disclosing considerable bias against the delinquent. The apex court went on to say that such a state of affairs shocks the notions of judicial propriety and fair play. Agreeing with the findings of the High Court, the apex court held that the rules of natural justice were completely discarded and all canons of fair play were grievously violated by the presiding officer. Decisions arrived at by such a process was held to be not valid and binding. In the case of Sheshagiri Rao Supra, the apex court relied upon the aforesaid decision of the apex court in Muhammad Noor and reiterated the same view. In the case Arjun Chobe, the apex court set aside an order of dismissal passed against a railway employee after noticing that the order was passed by the authority who had leveled the charges against the employee. In that case, the main thrust of the charges against the employee related to his conduct qua the said authority. Lordship got it, the second is. Therefore, it was not open to the said authority to sit in judgment over the explanation offered by the employee and to decide that explanation as untrue. The apex court held that no person could be adjudged in his own cause and no witness could certify that his own testimony was true. The apex court observed that anyone who had a personal stake in the inquiry must keep himself aloof from the inquiry. In that case also, the apex court relied upon the aforesaid decision of the apex court in the case of Muhammad Noor. In the case of Nandakishore Supra, a division bench of Madhya Pradesh High Court held that the disciplinary authority who had issued the charge sheet on the basis of the materials which came to his knowledge could not have appeared as a witness in the inquiry. Same view has been expressed in the case of Kulendra Lohakar Supra. In the instant case, the disciplinary authority who had issued the charge sheets cited himself to be a witness and in fact deposed against the petitioner. Thus, it is case of disciplinary authority recording his own testimony against the petitioner, disclosing a state of mind which clearly discloses considerable bias against the petitioner. In all fairness, he ought to have dissociated himself from the inquiry proceeding, but instead showed his overzealousness in the matter by becoming a witness to bring home the charges against the petitioner. In view of the above, it is held that the disciplinary authority could not have cited himself as a witness and become a witness against the petitioner in respect of the charges leveled against him by himself. Thus, the issue number D is answered in favor of the petitioner. And now, Lordship, this is AIR 1983 SC 109, Lordship.
Yeah.
1983, third decision, Lordship. The Board of Trustees of the Port of Lordship. Para 10, Lordship. Page 4, para 10, Lordship. Even in a domestic inquiry, there can be very serious charges and adverse verdict may completely destroy the future of the delinquent employee. The adverse verdict may so stigmatize him that his future would be bleak and his reputation and livelihood would be at stake. Such an inquiry is generally treated as a managerial function, and the inquiry officer is more often a man of the establishment. Ordinarily, he combines the role of a presenting cum prosecuting officer and an inquiry officer, a judge, and a prosecutor rolled into one. In the past, it could be said that there was an informal atmosphere before such a domestic tribunal, and that strict rules of evidence and pitfalls of procedural law did not hamstring the inquiry by such a domestic tribunal. We have moved far away from this stage. The situation is where the employer has owned his payrolls, labor officers, legal advisors, lawyers in the garb of employees, and they are appointed presenting cum prosecuting officers, and the delinquent employee pitted against such legally trained personnel has to defend himself. Now, if the rules prescribed for such an inquiry did not place embargo on the right of the delinquent employee to be represented by a legal practitioner, the matter would be in the discretion of the inquiry officer, whether looking to the nature of charges, the type of evidence, and complex or simple issue that may arise in the course of inquiry. The delinquent employee, in order to afford a reasonable opportunity to defend himself, should be permitted to appear through a legal practitioner. Why do we say so? Let us recall the nature of inquiry, who held it, where it is held, and what is the atmosphere. Domestic inquiry is claimed to be a managerial function. A man of the establishment donned the robe of a judge. It is held in the establishment office or a part of it. Can it even be compared to the adjudication by the impartial arbitrator or a court presided over by an unbiased judge? The inquiry officer combines the judge and prosecutor rolled into one. Witnesses are generally employees of the employer who directs an inquiry into misconduct. This is sufficient to raise serious apprehensions. Add to this uneven scales the weight of legally trained minds on behalf of employers simultaneously denying that opportunity to delinquent employee. The weight, scales, and tilted balance can only be partly restored if the delinquent is given the same legal assistance as the employer enjoys. Justice must not only be done, but must seem to be done is not an emphasis for courts alone. It applies with equal vigor and rigor to all those who must responsible for fair play in action. And a quasi-judicial tribunal cannot view the matter with equanimity or inequality or of representation. So these are the discussions regarding whether the delinquent was given any chance to place his case, Lordship. He was not even allowed to accompany any high official from his own Lordship. And he asked for advocate's assistance, that was negated, Lordship. And one more decision, Lordship, that is 1984 1 GLR page 40, Lordship. That was also in respect to the assistance of some other person to the delinquent. The steps to be taken in the proceeding, that is paragraph 13, page 51, Lordship. Regarding that, there cannot therefore be any doubt about the proposition that Rule 66 of Assam Police Manual cannot supplant the constitutional mandate of Article 311, and the same has to be read as merely supplementing the minimum constitutional safeguards provided therein to a civil servant. In our opinion, therefore, reading together Article 311 and Rule 66, the consecutive steps in the disciplinary proceeding which have to be taken in respect of a person subject to these rules can be summarized as follows. First step, the delinquent will be informed of the charge with which shall be furnished to him statement of the allegations, which in the course of any preliminary inquiry, the disciplinary authority may collect, and the inquiry as contemplated by Article 311(2) into the charge will then follow, and the same will commence only after the charge, duly communicated to the delinquent as a sequel to or on the basis of the investigation made in the course of the preliminary inquiry. Second step, the inquiry into the charge contemplated under Article 311(2), postulating the requirement of reasonable opportunity being afforded to the delinquent, will necessitate evidence being taken in support of the charge if the charge is not admitted. Indeed, this is also contemplated by Rule 66 itself, although it is necessary to clarify that the requirement of the rule, if he so desires or if the authority concerned so directs, must be so read as to conform to the constitutional imperative embodied in Article 311(2). Taking of evidence to establish the charge after the same is communicated to the delinquent in view of the constitutional imperative cannot be dispensed with except in the manner provided by the constitutional provisions itself, namely the exceptional cases covered by the proviso to Article 311(2). Hearing the delinquent in person, taking evidence offered by him, and communication of the decision arrived at thereafter on the charge will conclude the state. So, Lordship, there was no evidence taken from the delinquent in defense, Lordship.
According to the inquiry officer, you refused to take witness.
Lordship, that was not correct, Lordship. It was written by the inquiry officer in that case, and I have submitted my second show cause reply, Your Lordship, along with the evidences of doctor and victim in the criminal trial. What are the evidences they have adduced before the trial court? That also I have enclosed along with my second show cause reply. That can also be taken into consideration, Lordship. They simply said that I have denied, Lordship. That was, those evidences were not considered, and I was not given any chance to adduce some other evidence, and Lordship take the assistance of advocate. And one more thing, Lordship, my third limb of argument is that, Lordship, when criminal trial is pending, Lordship, if the offense is, Lordship, the charges are on the same offense, it is desirable to stay the departmental proceeding. It is not mandatory that it can be state, it should be state, Lordship, but it is desirable to stay the departmental proceeding, Lordship. He has been, Lordship, dismissed from his service, Lordship, before, much more before his retirement age, Lordship. So the person is suffering, his livelihood is depending upon his service only, Lordship. On that ground, Lordship, our High Court decision is there, Lordship, that is number 5 decision I have given, that is 1 WPC 8143 of 2022. Here in a small paragraph, Lordship, it was written in paragraph 15. Para 15, Lordship, page 10. Last paragraph. As noticed above, the impugn order dated 24/3/2022 was issued by the authorities after taking note of a number of documents and statements of the witnesses. The observation made in the impugn order further goes to show that The petitioner has been declared to be a criminal even before he was convicted by the trial court. Moreover, the order also clearly puts a stigma on the petitioner. The petitioner is facing trial in a criminal proceeding arising out of an FIR lodged by the authorities, but he is yet to be convicted. It may so happen that eventually the charge framed against the petitioner may be established in the criminal court. However, since there are allegations brought against the petitioner based on materials collected against him, principles of fairness and natural justice demanded that at least one opportunity was afforded to the petitioner to explain. In this case, Lordship, no inquiry was held and he was directly placed under suspension. So in that regard, it was held that, Lordship, without any inquiry, the person cannot be dismissed from service. But while saying so, Lordship, it was also stated that even before he was declared as a criminal by the criminal trial court, Lordship, he was dismissed from service, saying that he is a criminal, Lordship. In that regard, Lordship, that is 1999 3 SCC, Lordship. This is the last citation I am citing. Para 22 2, Lordship. That is page 691, Lordship. Para 22, the conclusions which are deducible from various decisions of this court referred to above are departmental proceedings and proceedings in a criminal case can proceed simultaneously as there is no bar in their being conducted simultaneously, though separately. Now, second point, Lordship, it says if the departmental proceedings and the criminal case are based on identical and similar set of facts and the charge in the criminal case against the delinquent employee is of a grave nature, which involves complicated questions of law and fact, it would be desirable to stay the departmental proceeding till the conclusion of the criminal case. So my humble submission before your Lordship, where is the Lordship?
Anyway, that is over now.
Lordship.
That is over.
Lordship, these are my
What
submissions.
happened to your criminal case?
It is under process, Lordship. The prosecution witnesses are going on.
Trial is good.
So my humble submission, Lordship may set aside the dismissal order, Lordship. He may be directed to be reinstated in his service, Lordship.
Lordship, it's my finish. Lordship, first of all, I'd like to begin with one particular judgment of the Honorable Supreme Court, a very latest judgment. Pleadings which are not released, which are not part of the pleadings, cannot be granted. A very recent judgment of the Honorable Supreme Court, its citation is AI 2022 SC 3544. Therein, the Honorable Court specifically stated, reliefs which are not part of the pleading cannot be granted by any court. So here, I take the two particular submissions. One is appointment of defense. First is appointment of defense witness. That particular pleading, nowhere in the writ petition. Therefore, we could not counter that particular allegation in a counter affidavit. And as the Honorable Supreme Court has stated, that since we could not counter because that was never part of the pleading, that cannot be looked into. Secondly, is the issue of presenting officer being a witness. That particular point is also not part of the pleading in the present.
You've not taken those pleadings.
Lordship, on some other grounds, it was mentioned that on the other grounds, I can include my pleadings. I can elaborate,
No.
Lordship, my arguments.
In my humble submission, that cannot happen. That was never, those 2 points, we can put them because they were never part of the pleading. Now, only point which has been taken by my learned friend in the pleadings is the cross-examination of witness as to whether opportunity was granted to the petitioner to cross-examine the witness on. They have stated so. We have stated that he was granted ample opportunity. And on last occasion, we were actually invited to produce the records. I have got the records, Your Lordship. I have flag marked the witness's statement as well as the opportunity to cross-examine the witness and his denial to cross-examine them with his signature. I have marked them specifically, Your Lordship. flag mark number 1.
Yes.
1, 2, and 3, Your Lordship. Therein, at the bottom, specifically stated, and the signature is also mentioned of the petitioner himself, Abdul Razak Mandal,
Where?
at the bottom, Your Lordship. Sideways, Your Lordship. Like this, sideways.
It's in Assamese.
It's an Assamese.
Have you translated it? At least,
It's part of the original records, Your Lordship.
at least you could have translated.
Yes, Your Lordship, but that was the question was with regards to the opportunity to cross-examine the witness, Your Lordship. That is in English. That's why, Your Lordship, I pointed that out. The statement of the witnesses were never in question. That is never in question. Yeah. The only ground that
I'm
was
not
taken
denying
was
that I
basically
was not allowed
cross-examination.
to examine. Lordship, I was asked to put my signature on some of the documents that I have already stated before, Your Lordship. They are my employer. They asked me to put my signature in the documents I have signed, Lordship. That much I am not denying, Lordship.
That is not, that cannot be looked into any writ court, Your Lordship. That is appreciation of evidence cannot happen. That particular point he could have raised before the inquiry officer as well as the disciplinary authority. Nowhere in the representation could we see that particular point. That he could not cross-examine the witness, or he was just made to put the signatures. No, this is just an afterthought. And so if we cancel out those two, one is appointment of defense witness, which is gone. And the other one is a presenting officer being a part of the, being a witness, that is also gone. Even though we go
Where's
into
the
the
judgment?
judgment copy, Your Lordship, I actually just found it. And if Your Lordship can actually note down the citation, I'm very sorry for that because
No, you bring a hard copy.
and then I'll provide after some time, Your Lordship. But the fact is that judgment.
You do one thing, you get a copy, we'll take up tomorrow or day after.
Tomorrow, you know, tomorrow or day after tomorrow, you know.
Also heard the Deborah. Then a governor split. For the response.
This.
13 part is for 40 getting. Will that be on the Thursday?
Thursday, Your Lordship.
25th. You keep this with you?
Yes, sir. Thank you.
16 and 17.
There's one production is. Huh? It is not. Hold on. Up to something.
Yes. Item 1 of production list, Zahirul Islam versus Union of.
Here the petitioner is, my lord, serving in the Central Reserve Police Force as a constable driver. Now, he was posted at the 130 Battalion of the CRPF, my lord. And regarding an incident which took place in the year 2021, the commandant of 34 Battalion conducts an inquiry and imposes the punishment of compulsory retirement on the petitioner. The first ground that the petitioner wants to take is, my lord, that he not being under the superintendence and control of the commandant of the 34 Battalion. The commandant 34 Battalion would not be the appropriate authority to initiate the disciplinary proceeding, first of all. Secondly, to order his compulsory retirement and thereupon asking the commandant of the 130 Battalion to remove him from service. That lordship would find, my lord, that improved order I have annexed. We'll come to the allegation also, my lord. Lordship may like to have page 41, my lord. the relevant portion of the order, my lord, which I am agreed with. Serial number 2 is the petitioner, my lord. Constable Driver Jahelul Islam is imposed the punishment of compulsory retirement from service with effect from 30/4/2024 with all admissible pensionary benefit under provisions of Rule 40 and 44 of the CCS pension rule. Accordingly, the formalities for issuing PPMS order removing him from service with effect from 30/4/2024 be taken up by 130 battalion. And this is, my lord, issued by, if lordship has the first order, my lord, order is, lordship will find it page 22. It is issued by the commandant of 34 battalion. And that is the first legal issue, my lord, that has to be answered by the respondents. That is the first part, my lord. The second part is 2 charges were leveled against the petitioner, my lord, in the memorandum of charge. The first charge is that another person left his duty post, came to my bed and shot me. That lordship will find the memorandum of charge at page 68 onwards, my lord. The first charge is at page 70. Article 1, lordship finds at page 70.
Yes.
That number so-and-so, Jushil, headquarter 34 battalion, presently posted at 180 battalion, and force number so-and-so, while functioning as constable driver, Central Reserve Police Force, committed an act of insubordination, dereliction of duty, misconduct, or indiscipline, in that on the night intervening 10 and 11/7/2021, Constable Raju Shil, without permission of his senior commandant during his duty hours, came to empty line with his loaded weapon with an excuse to give tobacco to force number so-and-so with some other intent and fired at him. Constable driver Jahelul Islam woke up at the sound of gunfire. In the ensuing scuffle, both received minor gunshot injuries, whereas in this region, there is no provision to carry weapons to the lines or residence. Act done by both the employees. My lord, this Raju Shil comes from his duty post, leaves his duty post without any permission, brings his gun and shoots me. I have been punished with compulsory retirement. So therefore, my lord, this is a charge which I could not have been held guilty even on the face of it, my lord, even when the charge is being framed. Raju Shil came to my bed and Raju Shil shot me. This is, my lord, the second aspect of the matter. And thereafter, lordship will find the FIR lodged by the respondents themselves at page 65. Original is at page 67. Page 65 is the type copy. May I read, my lord? It is submitted that on 10/7/2021, Raju Shil of so-and-so was detailed for Morcha sentry duty from 2200 hours to 2400 hours at Morcha number 5 on MT Park. On 11/7/21 at around 0400 hours, Raju Shil of this unit entered the empty line after completion of his duty and fired upon Jahelul Islam, who was sleeping in his bed in the empty line. In that fire incident, Jahelul Islam of this unit got injured in his leg, leg, thigh and right hand as well. After that, Jahelul Islam tried to snatch the weapon, carbine, from Constable Raju Shil, resulting 3 rounds was fired from the carbine by both personnel during snatching of weapon by each other, and Raju Shil got injured in his leg calf. In this regard, you are requested to register a case and take legal action against Raju Shil. Now, all said and done, my lord, here is a person who was attacked while he was sleeping in his bed by one Raju Shil, and the respondents, my lord, they hold me also guilty of their incident, and Commandant 34 Battalion compulsorily retires me, whereas I am serving in, my lord, 130 Battalion, requesting 130 Battalion to remove me from the rolls, my lord. As of today, my lord, I am praying that if a notice is issued, and my lord, this compulsory order, which is to take effect from 34/2024, it has not been given effect as of now. But yesterday, they have recalled back my identity card, they have recalled back my health card, my everything. So, my lord, we are in an apprehension that they will give an effect to it on any day from today, my lord.
Lordship, as it is, the order will be effective from 30th of this month. Lordship will take this matter on 29th.
The difficulty is I am not here on the 29th. I'll be back on the 2nd.
His colleague can be there, Lordship. At least I need some time to get the instructions. I'm not making an unreasonable play, Lordship. Let it be on 29th, Lordship. Lordship will only have to see the instructions. He has made his submissions, but Lordship, I've gone through the whole petition. The inquiry reveals something else. The other person has been dismissed from service.
Yes, that is also.
The other person has been dismissed from service. He has been compulsorily retired. From what transpires from the inquiry, Lordship, there are some materials, but let the instructions come, Lordship. Let it be on 29th. It's Monday, Lordship. Today is 23rd. Let it be on
My
29th.
absence will be only the only difficulty. Otherwise, my lord, if lordship permits, I'll be there on DC then. my lord.
Yes, yes.
That is the only.
Let it be on.
And in the meantime, my lord, since they're trying to take away my identity cards and my health card and everything, my lord, that effect may not be given, my lord. Let the
Order will be
others
effective
will
from
come later on.
30th, Lordship. At least before that, Lordship will not pass.
Or lordship may say that before 29, no other coercive action. Even that would be.
That R. Majumdar, learning council for the petition. On request made by Mr. R.K. Dev Chalvi, Please the matter again on 29th April to enable him to receive instructions. I don't think any coercive steps will be taken.
All they're doing is they're harassing me by taking. Anyway, my lord, if lordship keeps it for 29.
No coercive steps taken again. In the next return.
Lordship.
Till the next return, that not coercive step.
Further interim will be considered on that day. my lord.
Fair point.
No, like, Lordship.
Obliged.
Sixteen and 17 hearing.
May pleasure. There, my lord, in this case, my lord, petitioners were, my lord, appointed, my lord, in the year 93 and 96, my lord, as additional mandal, my lord. Subsequently, my lord, my lord, subsequently there was a move, my lord, for regulation of their services, my lord, and they were accordingly, my lord, adjusted in absorbed in different district, my lord. And as there was some local resistance from the said area, my lord, in that area, they were again back to the earlier place, my lord, where they were revert back to their earlier place where they were working, my lord. And accordingly, in this way, my lord, they were working till that, my lord, till today, my lord. And they, what is happened, my lord, in the meantime, government has, my lord, regularized some of the additional mandal as a regular basis, my lord. Subsequently, in between them, my lord, there were some cases filed by the petitioners and their colleagues, my lord, additional mandals. In the meantime, they were regularized, my lord. And in that case, my lord, earlier order, my lord, they specifically that order in earlier order, that that order was passed for regulation of their service for accommodation, my lord, in absorption, my lord, etc. Now, my lord, in the meantime, what has happened, my lord, some advertisement published, my lord, they even participated, my lord, at these old days, my lord. Petitioner number 1 completed 28 years and petitioner number 2, 31 years, my lord. Here, my lord. And some of them, their colleagues have been already, my lord, adjusted, my lord. Here, my lord, first I want to place, my lord, their, my lord, appointment letter on us, my lord. Or your lordship may also peruse your lordship earlier order, my lord. First round of litigation, my lord, that was page, my lord, 42, my lord.
Page 42.
Yes, page 42 of the writ petition. The deputy petitioner's case in brief is that they have been working as additional mandal in the different circles of Goalpara district since 93 to 96. The Deputy Secretary to the Government of Assam Revenue DM Department issued a letter dated 11/2/2009 stating that the government had taken a decision to absorb additional mandals against regular post of mandals now laying vacant under the establishment of Deputy Commissioner of different districts. Accordingly, it was requested that steps for absorption of the additional mandals should be taken against available vacancies. Therefore, various orders, a number of additional mandals were absorbed into regular vacancies. The petitioners' council submits that while the petitioners were under the legitimate expectation that they would be absorbed against regular vacancies, the state respondents published an advertisement dated 14/12/2005 for filling up of 7 regular vacant posts of lot mandals by way of direct recruitment. The petitioner council submits that a policy decision having been taken by the state respondents for filing up of regular vacant post of lot mandals by absorption of additional lot mandals. The advertisement dated 14/12/2015. It was earlier that it has to be 14/12/15. Should be set aside and a direction should be issued to absorb the petitioners to regular vacant post of lot mandals. So Learned Council so for the status submits that the petitioners can be considered for absorption to the regular vacant post of lot mandals in view of policy decision taken by the state respondents. She, however, submits that the impugned advertisement dated 14/12/2015 should not be disturbed. I have heard this also. In pursuance of the policy decision taken by the government and as communicated by the letter dated 11/2/2009 issued by the Deputy Secretary to the Government of Assam, additional lot mandals are to be absorbed into regular vacant posts of lot mandals. Thereafter, the Deputy Secretary to the Government of Assam, Revenue and DM's Department has issued another letter dated 11/6/2009, which is to the effect that the Government of Assam, in the interest of public service, has been pleased to redeploy the additional mandals to the original post of additional mandals under their respective settlement office and ensure that they are absorbed in order to seniority in clear vacant post of additional mandals, which occur from time to time. In the establishment of the Deputy Commissioner of the respective district where settlement operation is going on. A seniority list has also been issued by the settlement officer Gwalpara in respect of additional mandals who are working in the Gwalpara district file letter dated 36/2014, showing the names of all petitioners herein. The apex court in the case of Secretary State of Karnataka versus Uma Devi Sonso has held that paragraph 53 as follows. 53 paragraph has been quoted here, my lord. Thereafter, my lord, next page 45. In case of Karnataka, yes, my lord. Paragraph 10. In case of so-and-so, ML Kesri and others, the apex court has held that at paragraph 10 as follows. As at the end of 6 months from the date of decision of Uma Devi, 3 cases of several daily wages ad hoc casual employees were still pending before courts. Consequently, several departments and instrumentalities did not commence the one-time regulation process. On the other hand, some government departments of instrumentalities undertook the one-time exercise in excluding several employees from consideration either on the ground that their cases were pending in the courts or due to share oversight. In such circumstances, the employees who were entitled to be considered in terms of the para 53 of the decision Uma Devi Sonso will not lose their right to be considered for regulation, merely because the one-time exercise was completed without considering their cases, or because the 6-month period mentioned in paragraph 53 of Uma Devi has expired. The one-time exercise should consider all daily wage ad hoc casual employee who had put in 10 years of continuous service as on 10/4/2006 without availing the protection of any interim orders, courts or tribunal. If any employer had held the one-time exercise in terms of the paragraph 53 of the Uma Devi 3, but did not consider the case of some employees who were entitled to the benefit of paragraph 53 of the so-and-so. The employer concerned should consider their case also as a continuation of one-time exercise. The one-time exercise will be concluded.
I have read it.
Yes, madam. The apex court Uma Devi, accordingly in view of the above reasons, next paragraph, findings, my lord. In view of above reasons, the state respondents are directed to consider regulation and absorption of the petitioners to the regular vacant post of lot mandals available in the Gwalpara district with respect to all those petitioners who have not retired as on date. The entire exercise should be carried out within a period of 3 months after receipt of permission. So the state respondents are also directed not to give effect to the advertisement 14/12/2015 till the petitioner are considered for regulation absorption and a decision taken in their respect of the state respondents. Subsequently, my lord, we have submitted representation but they have published another advertisement in the year 2021 and page, my lord, 50 and 13, my lord. Advertisement page 14, sorry, my lord.
Page,
Page, my lord, 51.
1 minute.
Thereafter also filed writ petition, my lord.
Page,
Lordship,
page.
page 51, my lord. This advertisement, new advertisement was published 27/12/21, page 51.
Yeah, and which writ petition?
Oh, yes, my lord. Writ petition is 1954.
That is the second writ petition.
1954.
Yes.
In that advertisement, again, as fresh advertisement was published, my lord, we filed writ petition before this honorable court, and that is also, my lord, here I have annexed the order, my lord, page 55. Against the said advertisement, this order has been passed, my lord, on its silence. The petitioners herein are serving as additional mandal at the Matia Revenue Circle coming under the office of the Deputy Commissioner Gwalpara. As per the case projected in the writ petition, the petitioner number 1 had joined service on 96 and petitioner number 2 joined service on 93. Accordingly, they had rendered their services 26-29 years respectively. Although the petitioners had made several applications for regulation of their service against the vacant post of Latmondal, and notwithstanding the specific direction contained in the order dated 6/12/17 passed by the Honorable Court in WPC number so-and-so, as well as communication letter dated so-and-so issued by the Additional Deputy Commissioner Gwalpara, the name of the petitioners have been dropped from the select list of candidates for recruitment of Latmondal in the establishment of Deputy Commissioner Gwalpara. Hence the writ petition. According to the respondents cannot appoint any fresh candidate as Latmondal without regularizing the petitioners in view of the order dated 6/12/17. I have already read this order, my lord. My lord Justice Michael passed this order passed by this honorable court. Jehendik Lanet Constituency pressed for 4 weeks time to obtain instruction by submitting the selection process is going on, but on appointment order, no appointment order has been issued till today. In view of the above issue notice so and so. That order was passed, and considering the interim order page 56 or facts and circumstances of the case, it is hereby provided that the respondents may go ahead with the selection process but shall not issue any order of appointment to any candidate against the post of Latmondal without the leave of this court, my lord. But as they have again published another advertisement, next page, 11 March 2022, page 57, annexure 18, for filling up 8 posts, my lord. We have filed this instant writ petition, my lord.
Is there an interim order?
Interim order is there, my lord.
They were asked to, my lord, apply for the debt post, my lord, they did not apply. But may I kindly see the order?
Earlier applied, my lord. Why at the age of
Then, my lord, in person to this order also, lordship, the honorable justice, the lordship, this order was passed on, lordship.
earlier
On
petition they applied for.
2022.
Yes, there was interim order, my lord. Earlier order.
Yes, then.
My lord, earlier repetition, my lord, we have already applied in that case. Subsequently, at the fag end of our retirement at the age of 58, 59 years, my lord, it is not actually, my lord, possible. But in spite of that, earlier as advertisement was there and court direction was there, my lord, we applied for. But when the case was before the honorable court, in view of the second order, my lord, in the express repetition, as we did not appear, my lord, in spite of that, honorable court thinks that, my lord, if he did not appear, thereafter, my lord, case has been again, my lord, before this honorable court, my lord. But what has happened, my lord, already order has been passed 2-3 occasions, my lord. And in spite of that, our colleagues have been all, my lord, already regularized, my lord. Just we are too left behind, my lord. Our petitioner kindly peruse your lordship, earlier order, my lord, page 41. Page 41, earlier read petition, my lord, 8004. Here, my lord, petitioner number 1, 2, 3. My name is, my lord, at serial number 4, 1 of the petitioner. 5, 6, 7, all were, my lord, already regularized, my lord. And another petitioner is at serial number 8. This petitioner, my lord, here. 4 and 8 left of, my lord. In view of this order, my lord. Earlier also, my lord, passed one similar order, my lord. That was repetition, my lord. That order was passed on, my lord, page 39, next 10, my lord.
Page
39. It was actually cohort case, that's why that order was passed. That order is also along with me now, my lord. So and so, Mr. Das, counsel for the who submits that a writ petition mandamus should be issued to absorb the petitioner against the existing vacant post of Latmondol in different circles under the Deputy Commissioner Gwalpara. He also submits that the present case is covered by the judgment of the court passed in WPC 98211, Fight Order dated 6/9/12. The relevant portion of the order 6/9/12 is reproduced below. Petitioners therefore deserve to be considered for regular absorption as mandals against the existing vacancy, if any, in Dhubri district. Hence, the state respondents are directed to consider the case of the petitioners for absorption as mandals in the establishment of the Deputy Commissioner Dhubri, maintaining their seniority along with other additional mandals, if any, in that district within a period of 3 months from today. In the meantime, 9 posts of the mandals in the establishment of Deputy Commissioner Dhubri, if available, shall not be filled up. It is needless to say that in the event of adequate number of regular posts of mandals is not available, consideration for absorption of additional mandals shall be made on seniority basis. It is also needless to say that the interim order passed earlier has merged with the final order passed. Mr. M. Chaudhary Lanet, counsel for the respondent number 2, and Vijay Talukdas, counsel for the state respondent, submit that the present matters need no adjudication in as much as the case of the petition is squarely covered under the order dated 6/10/12 passed in WPC 982. In view of the agreement of the parties, this petition is disposed of in terms of the earlier order dated so and so. That order was passed by my Lord Justice BP Kotoki, my lord, and they have been already regularized, my lord. Although petitioner
all the additional lot mandals have been regularized.
already regularized, my lord. All
Except
these
to-
are the old person have been already regularized. These are more than 20 years, my lord. These workers are more than 20 years servicing there, my lord.
Immediately. Also, in the second file, also we have file on affidavit. Can you take up that affidavit, Lordship?
Which file?
Of number 1954.
Oh.
I'm directly coming to the point, Lordship. May I kindly see para
Respondent 3.
respondent number 3, para number 9, Lordship. Para number 9, at internal page number 4, Lordship. The last part of the para. Thereafter, an advertisement dated was published. Last part of the para number 9, Lordship. Thereafter, an advertisement was published by so and so dated 14/12/15 for filling up 7 numbers of vacant post of Latmondol in Gwalpara district. However, the writ petitioners and others again filed writ petition before the Honorable High Court of 8004 of 2015 was my letter and said, wherein the Honorable Court passed an order dated to 23/12/2015 and state the advertisement dated 14/12/2015. So see, after that, what has happened in the middle, lawsuit after 2015 and before the new advertisement of 2021, we have asked them to apply through proper channel, Lordship. Lordship, may kindly see para number 10. That at regards to the statement made in paragraph order, the text to state that on receipt of the prior petition dated 13/12/21 from the repetition 5 orders, the matter was discussed in the meeting of the selection committee held on 17/12/21 for filling out a vacant post of lot mandals, and accordingly they informed by data dated so and so to apply through proper channel for absorption regulation in vacant post of lot bundles as per government notification so and so. Then para number 11, Lordship.
Where's that letter?
Alexa, one of them. Page number 8, right?
In 912 case, my lord. That is there. That letter was is page 45.
If it been in reply.
No, in petition it is there. I have already mentioned there.
This is page number 8, Lordship, annexure A. Annexure A, Lordship.
Annexure?
Annexure A, page number 8.
No.
No, the absorption for like
27/12/2021 letter.
yes. In 912, my lord, I have annexed here. Page 45. Annexure 13. That
What's the name? Annexure C, Lordship.
side.
In front of the annexure M.
Page 45.
Yes, Lordship. Annexure C.
Accordingly, we appear there and our names were there in the result sheet also, my lord.
Where?
Written test.
Where's the result?
Annexure 15, page 47.
Then what happened?
In computer typing, they could not able to succeed.
Yes, Lordship, then.
Page 48. Just
He continue open.
after written test, they have and they were computer test, my lord. Page 48. Annexure 16, page 48. In that, in that result sheet, our names were not there. Our roll numbers were not there, my lord. Our roll numbers were at serial number, my lord.
When you see our numbers, do you mean petitioner 1 and 2?
Yes, yes, my lord.
Only the petitioner 1 and 2.
Yes, my lord.
Yes, proceed, check yes.
Lordship, after that, Lordship, they may directly come. Then para number 13, Lordship. The deponent begs to state that the office of the deputy commissioner Golpa only informed the petitioner to apply to proper channel for absorption regulation. After that, Lordship, that para number 14, the deponent begs to state that the candidates were selected on the basis of marks obtained in selection test written as well as computer, including 5 out of 8 numbers of additional mandals. Then Lordship, we see para number 16. This is important. Next we said as per government approval number so and so dated 9/3/22, advertisement was published by so and so for filling of 8 numbers post of lot bundle in Golpa district, but the lead petitioners did not apply for regulation absorption to the post of lot bundle in Golpa district, Lordship. Then again, para number 19, Lordship, the deponent begs to state as per government approval number so and so 9/3/22.
An advertisement was published 11/3/2022. Where's this advertisement? 11/3/2022.
11/3/2022. Next one,
Huh? Annexure 18 of. You say annexure 18 of repetition 1954. Page 57.
Page
57, Lordship. It was again being challenged by the petitioner, Lordship.
This is again challenge.
Yes.
Then
Lordship, after that, Lordship, as per government paper number 19 of my affidavit, an advertisement was published, that is 11/3/22, for filing of 8 numbers of posts of Lord. Accordingly, in persons of there is interim order, Lordship, passed by the Honorable High Court in respect of the writ petition 1954/22. The selection committee conducted test phase 1, phase 2, and appointed 6 numbers out of total 8. Out of total numbers of lot models, total 8 numbers of lot models. Ultimately, it is on the merit basis, Lordship. After conducting of the test, Lordship, the 6 has been cleared. Yeah. Or nahi ab.
no, the first judgment,
Lordship.
first judgment passed by this court. They did not provide for an advertisement. It provided for having a one-time measure to regularize.
Consider the, yes, Lordship, I have seen the order of, to consider the case of.
So after that, what did,
After that,
what did you do?
after that effect, they have done, they have filed another case.
No, no, no. You have filed in a, you,
Advertisement.
you advertised
To the victim.
the post. So they filed the case.
And state that advertisement.
Oh,
Lordship, may I submit?
My brother.
Lordship, may after the several petition, Lordship, my lord, that Lordship earlier, my lord. That the petition, my lord, 1954, Lordship. Lordship, kindly goes to the order dated. The annexure 10, page 39.
huh?
Annexure 10 in Lordship, my lord, WPC number 1954.
Yes.
Annexure 10, page 39. And Lordship, kindly see the, this is the order dated, my lord, 12/6/2015, Lordship.
This is the first case.
Lordship, it's the first case, my lord, that in pursuant to the, my lord, the repetition number 982/2011. Order dated so and so. My lord, this was initially, my lord, order was passed. After that, my lord, is the review. Lordship, may kindly goes to the my affidavit in WPC number, Lordship 912. The affidavit filed by respond number 2, Lordship.
Yes.
Lordship, in this, my lord, the affidavit, I have annexed the, my lord, that office memorandum. Lordship, may kindly goes to the page 32, I think, my lord, annexure I in internal page 8. Lord. Is, my lord, this is the, my lord, the absorption of additional Mondal, Lordship. Lordship, kindly see the order dated 23 September 2013, Lordship. After careful consideration all spec and in light of the Honorable High Court's order dated 25/5/2011 and order dated 6/9/2012 in WPC number 892/2011 and the order dated 6/5/2013 in WPC number 6030 of 2012 and 9 other similar cases following order dated so and so in review petition number 1/2013. Lordship. This order has been reviewed.
Where is the review order?
Review order, my lord, I could not find out, my lord, we could not annex this order. Lordship, I have to, my lord,
The review order that is
Lordship.
important.
And in person to this review order, this absorption, my lord, this, my lord, the condition has been, my lord, that, for regulation of the, my lord, service condition has been, my lord, put. And my lord, interesting, my lord, point is that, my lord, this office memorandum was not brought into the honorable courts on that day when that this order was passed earlier, my lord, 2015, Lord. This notification, office memorandum was issued on 2013. And my lord, this order was passed on 2015 and 2017. According to this office memorandum, whoever, my lord, they working as a, my lord, additional mandal, they have to apply and appear in the interview. They have to apply through proper channel. And Lordship, my lord, there some condition is there. The age relaxation, other things also there. So according to my lord, this, in person to this office memorandum, they have to appear in the interview, my lord. Those who are appeared in the interview, my lord, they are, as per the seniority, their service has been
So
regularized.
this office memorandum was issued on the basis of that review.
Lordship.
Where's the review order?
Lordship, my lord, sometime have been given. I have to, my lord, that apply for that post, my lord. That I was searching in the, my lord, net, my lord, I could not find a review order. 2013, my lord, that.
But Mr. H.K. Das, Standing Council. Mr. J. Hendrik, Leonard, Standing Council Revenue,
Revenue, Lord.
shall produce a copy of the order dated 23/8/2013. Passed in review petition number 1/2013. Correct.
Lordship.
When do you have one?
After 10 days, Lord. I have to apply.
Hit me.
All right.
Eighteen.
Regarding, but compulsory appointment, man. Maybe allowed to call me senior, maybe allowed to call me senior.
What is it?
You want to call this senior, maybe allowed to call me senior. Matter related to my lord, this is compulsory appointment. This is a petitioner, my lord. His father was working as a superintendent at Northeast Coalfields, my lord, at Tipong, my lord, Tinsukia district, my lord. He died doing harness, man. And he died on 15/10/2019. He died on 2017, my lord. Date, my lord, 15/10/2017. Then he filed an application because they have a not Coalfields, the Northeastern Coalfields, they have a scheme, my lord, for compensation and appointment. That NHB or Lordship kindly come to page.
Where's the scheme?
The scheme is, my lord, that is a memorandum agreement, my lord. That I have stated in my petition, my lord. Bipartite agreement between the coal industry and the workers' union, my lord. And as part of the scheme, my lord, I made an application, your lordship will find. That application.
Where's the scheme?
Scheme I have mentioned in my petition, my lord. That they have to, as part of, they have to.
Let us see, where have you mentioned the scheme?
Scheme, my lord, that I have stated in my.
You are claiming for compassionate appointment on the basis of the scheme, isn't
Scheme,
it?
and
You should have the scheme.
Scheme, my lord, that I have stated, my lord, in paragraph 8, my lord. Paragraph page 9, my lord. That National Coal Wage Agreement, a settlement agreement with trade union having affiliation with Central Trade Organization Coal Industry signed on 13/12/2012 as proposed in Industrial Dispute Act, which is contractual liability of 8 subsidiary companies of Coal India, and therefore same is found to be consistent with Article 15 of Constitution. National Coal Wage Agreement relates to dependent employment. Clause 9.3 of the National Coal Wage Agreement provides that
Dependent for this purpose means wife, husband, as the case may be, unmarried daughter, son, and legally adopted. It was further stipulated that as per clause 9, a jointly purported scheme relates to employment of one dependent of the worker who dies while in service. Therefore, the provisions of is a binding settlement under section 2 of the Industrial Dispute Act, having the force of law, and therefore terms of settlement, it was reasonably fair. So as part of the settlement, as part of the scheme, I made an application that you will also find at page 22, Annex 7. There's a pro forma. Then
Council, without the scheme, I don't think we can proceed any further.
Scheme, they have got a copy of the scheme.
We have a copy of the
Right
scheme.
now, don't have the copy with the particular the provision 9.3, 9.4, and 9.5. That provision right now we don't have. Otherwise, on the next step, we can produce the scheme.
Produce the scheme.
Because I've got a copy of the scheme, my lord. That's is there.
Because the relevant portion of the clause 9.3, 9.4, and 9.5 under the social security chapter 9.
Social Security chapter 9, man.
But that portion right now don't have, because it belongs to the earlier edition of the scheme.
I've got a copy of it. 9.3. You'll also make a link.
But do you have any other spare copy?
That is not disputed also, my lord, by the and regarding my entitlement. That was not rejected because of the scheme. Rejected is some other reason. No, rejected.
So what does the scheme say?
Scheme says about the
9.31.
9.3, 9.4, 9.5.
Any other dependents can get employment.
Yes.
Yes, so he died on 28/1/2017, my lord. That is Annexure 1, page 17 is a death certificate, my.
Page?
Annexure 1, page 17, my. His name is late Panchanand Singh, my lord. He was a superintendent, my lord, office superintendent. He died on 28/1/2017, my lord. Then as per the scheme, my lord. I made an application before the authority, my lord, concerned authority, Coal India Limited, Margeta, my lord.
Is the time limit for application under the scheme?
Within a reasonable time.
6 months, but
We are filed within the period of limitation.
On time.
Okay.
That was filed on 28/8/2017, my lord. Page 24 is the, it starts from page 22, my lord. Application is a format, my lord, prescribed format is there, my lord.
Yes.
There is a format, my lord, applied, my lord. And it was also it was countersigned by the block development officer, my lord, as well as the Panchayat, my lord. So ultimately, my lord, along with other documents, my lord, that was
You
submitted.
applied on 11/8/2017, correct?
Yes, my. It was on 12/8/2017, my. 12/8/2017.
Where is that?
That you will also first page itself, my lord. Page 22, my lord. down below, the signature is that 12/8/2017.
But the next page,
Next page, my lord, that is the signature. I have signed it on 11, but it was forwarded by the agent, my lord, on 12, next day, my lord.
okay, so it was 12 page.
Yes, 12/8.
Then
Then thereafter, my lord, the matter was kept pending. There was correspondence between the parties, my lord. And some documents were not available with me. And there was correspondence, my lord. And subsequently, we have come to know that it was rejected, my lord. Rejected on a ground, my lord, basically on one ground. The date of birth recorded in the service records of my late father, the first from the date of birth record certificate submitted by me. On that ground, there is like my identity is disputed. So my prayer for compulsory appointment was rejected. That is the ground. That your lordship will kindly say. I mean, that I made a RTI application, my lord. That your lordship will find.
where's your rejection order?
Rejection order, my lord, they have that by through RTI, they have given me, informed me, my lord.
Where's your RTI?
RTI, your lordship will find at page 45, my lord. Page 45. It was on 11/6/2022, my lord. 11/6/2022, I made an application. There, question number 1, my lord, I applied for the compensation job on 18/4/2017. Also fill up the dependent job form given by the department. What happened to the application form? Reply, your dependent employee case was processed and forwarded to CIL, Kolkata, for obtaining the competent approval. And same was not approved by the competent authority, CIL, Kolkata. Why I have not got the benefit of dependent job till date despite my mother and family members' recommendation? Same as point number 1. I have verified all the documents sought by the department related to the dependent job. What happened to me? Same as point number 1. I want to know the reason why the dependent job is not given to me. Your dependent employment case was not recommended by the screening committee, CIL, Coal India Limited, Kolkata, for offer employment due to non-establishment of genuineness of the identity of the dependent applicant, Amalesh Kumar. The same also been communicated to concerned authority, on the basis of which I was not recommended. On what basis I was not recommended competent authority, even after departmental accepted all the documents and evidence. Same as point number 4. Then the details have been, your lordship will find in next page, my lord. Page 46. That the column wise they have given, my lord. That is second column, your lordship will find. The committee did not recommend for the offer of appointment due to non-establishment of genuineness of the identity of the dependent applicant Amalesh Kumar due to mismatch in the date of birth in the document submitted by late Panchanan so-and-so. Date of birth recorded by late Panchanan Singh in service book that his son was mentioned as 1585, 1185, and late Panchanan submitted PS3 on 17/5/88, where date of birth was mentioned as 1187. In the matriculation certificate submitted by Amalesh Kumar, the date of birth is 15/10/88. Then your lordship will find, subsequently I made a further RTI application, my lord, that and they have given the detailed reply. Your lordship may kindly come to page 48, my lord. The details, reasons have been given. Paragraph question number 7, my lord. The dependent question number 7. With dependent employee, C. Amalesh Kumar was processed from the unit level and forwarded to area office, and same was also examined and verified at area level and forwarded to CIL Calcutta for obtaining competent approval by note sheet number so-and-so, dated 15/1/2019, and same was returned back to the NAC with the observation that hide number so-and-so. After compliance of giving observation, the case was again forwarded to CIL Kolkata on 1/11/2019. The said file was returned back to the NEC, which comment that the genuineness of the identity of dependent applicant Amalesh Kumar is not established on verifying the date of birth as mentioned in the service book and PS3. In view of the said committee does not recommend the offer of employment. The dependent employment case file of Sri Kumar was again forwarded to CIL for competent approval after compliance of the given comments by letter number 18/11/2020. Said file was again returned back to the NAC on 26/2/2021 with a comment that the committee recommends to examine the case as per decision of the sub judice dependent employment of Sobhik Sengupta. The said file was again forwarded to CIL Calcutta after receipt of dependent case file of Sobhik Sengupta. Dependent employment case was returned back with NSC with comment that genuineness of identity of the applicant. Omnesco has not been established as there is no reason to make any changes in the recommendation dated 9/4/2022, which did not recommend the offer of employment due to non-establishment of genuineness of the identity of the dependent applicant. So on the ground, my lord, there was a difference in date of birth recorded in the service book of my father, and the certificate given by me, matriculation certificate. So they have rejected me on the ground that genuineness of the identity is disputed. So that is the ground. So my humble submission before, because date of birth will be governed by the documents which are available, the statutory documents. The documents, that is the matriculation certificate and my birth certificate. And those certificates are very clear that I was born in 1988, man. Maybe my father, to some reason or whether they have recorded the incorrect date, man. Whether that can be the ground for rejection, man. Whether that is the relevant material for rejection, man. How can it be that be ground for that dispute my genuineness? Only on the ground that my death certificate, the birth certificate does not tally with the date of birth recorded in the service book of my late father, man. So grounds for rejection are totally vague, my lord, and irrelevant, my lord. It's not a correct consideration. And there was mechanically, in order to deprive me from employment, this has been done, man. That cannot be a ground for that identity of a can cannot be disputed only on the ground that there is a dispute in the date of birth, man. I've given affidavit, I've given everything. Because we have to go by the statutory documents which were made available. The documents means matriculation certificate. And the certificates, these are all certificates issued by the compound, by the board, as well by the authorities, man. And they have saying that the certificate doesn't tally with what was recorded in the service book on that ground that my identity is disputed. Whereas the local Gavura, everything, even the local officer, field officer has certified it that yes, he's the son. So when the question of a dispute of the identity doesn't arise, man. So it's only on the ground that in order to deprive me from getting employment, it's only on technical ground it has been rejected, which is and doesn't show nothing to do with the identity of the person. So my humble submission before the grounds that we have found.
Where's the certificate from the Kanpura?
That you will also find the certificates I have enclosed by that. I was passed out from Bihar School Examination Board, my lord. That is 15/10/88. Bihar, my lord.
Where is that?
That page 18, my lord.
Page?
18, my lord. Then Bihar Intermediate. Then birth certificate also I have enclosed, my lord. And lecture 5, my lord. Page 21, my lord.
Then where's the certificate?
Yes, then you will also find the identification certificate issued by my lord. Lagao Panchayat, my lord, that you will also find at page 27, my lord. By the Lakapani Gao Panchayat, my lord, president of the Gao Panchayat, my lord. Page 27, my lord. I have given a declaration, my lord, where date of birth was written as 15. And it was signed by the Lakapani Gao Panchayat, the president of the Gao Panchayat, my lord. 21/8/2017, when my father walked, my lord. It was countersigned by the video of Margeta Development Block, my lord.
Page 27.
Page 27 and 28.
No, this is from the Northeastern Coalfields.
Yes, there is a format, my lord. They have to countersign it. the local Gaon Panchayat has to certify. Next page, your lordship. My photo, along with the photograph, they have to certify me that I'm the person, man. By the Lekhapani Gaon Panchayat on 21/8/2017. And that was countersigned by the block development officer, man.
Yes.
That's all. And personnel department also, my lord. Personnel department of the Northeast Coalfields, my lord. They have also given a certificate by the designated officer, my lord, regarding my identity, my lord. Page 36, page starts from page 33, my lord. 33. I've given the details of my family members, 34, my lord. The date of birth as per matriculation certificate also was given, my lord. The next page, page 34, 36 is by photograph, my lord. And the certificate was issued by the medical officer, my lord, of the Tipap Gate, the competent authority at Tipong, my lord, where my father worked, my lord. So there are other certificates also, identification certificate issued by the other authorities who are the employees of the NEC Coalfield, my lord. There's one electrician and one driver. So my identity was never disputed by at any point of time, my lord. The employees of the coalfield also has stated that yes, he's the son of so and so. The panchayat, my lord, president of the panchayat, she also put on the basis of a certificate produced by me, they have countersigned it by the block development officer. Now,
So who's rejecting your case?
by the approval authority, my lord.
In
On the
Kolkata?
ground that my date of birth recorded in this certificate does not tally with the date of birth recorded in the service book. And so and on that ground that so genuineness of my identity is disputed, man. Whether it is a ground for rejection, man. So that cannot be the ground for rejection, man. Maybe, but my father, on what basis he has written the date of birth may not be correct, man. But we have to go by the certificate, man. So my with your lordship, my that the consideration for rejection is totally irrelevant, vague, man. That cannot be a ground to dispute the genuineness of the identity of the person, man. When all the identification certificates were signed by the local authorities, man.
Your birth certificate was issued after the death of your father.
No, my lord, it was birth certificate was the
It was issued on 11/5/2017, isn't it?
it was attested on it was 11/5/2017 date of issue, my lord. Date of registration was 5/5/2017, my lord.
Oh, where's that?
That is Annexure 5, my lord.
Oh, I'm on the page 21.
It was issued on 11/5, my lord.
11/5/2017.
17, my lord. Yes, my lord. This is it.
So after the date of your father.
Yes, but other certificates are there, my lord. That is my matriculation certificate and my intermediate education.
When did you pass your matric?
On 15/10/88. That was on date, my lord, to 2004, my lord. It was held on 2004, my lord. Most probably 2005. 2004 itself, my most probably it was. Then Bihar Intermediate Education Council, my lord, where I passed mass intermediate. That is in 2006, my lord.
2004, you passed your metric.
Yes. There it is also 15/10/2088, my lord. Then Annexure 4, my lord, that is Bihar Intermediate Education Council, my lord.
Annexure?
Annexure 4, my page 20, my lord. That is in 2006, 31/12/2006, my lord.
Yes.
Fully. So, my lord, the documents, my lord, which I furnished, my lord, clearly shows that that can be a ground for doubting the genuineness of the identity of the person. My lord. When the prescribed format, I have given the identity, my lord. It was counter-checked by the local government, local panchayat, my lord. And the authority of the, as well as the employees of my father, my lord, who were working with me. They also put signature as a witnesses. So how can it be the ground for that my identity is not correct? In their affidavit, my lord, what they have done, my lord, they have taken one point, my lord, that is your lordship will find in the affidavit, my lord. That your lordship will find at page 92, my lord, last page, my lord. That is the ground they have given, my lord.
Page?
92, my lord, last page.
Yes.
There a phone number dependent employment case so was placed before the CIL on 4/2/22. One of the
No,
case.
no, 1 minute. Annexure 16.
Annexure 16, yes, my lord. Annexure 16, my lord. Last page, my lord. Total phone number of dependent employee cases file of NEC was placed before the CIL screening committee. On 4/2/2002, one of the case file is placed regarding the dependent employee, Deswag Amalesh Kumar, son of late so-and-so. OS, Office Superintendent of Tipong, Colliery, NEC, which was earlier placed before the committee on 2/8/19, 4/9/2020, 8/1/2021, 24/2/2021. Committee in its meeting held on 4/9/2000 did not recommend for offer of appointment due to non-establishment of genuineness of the identity of dependent applicant Amalesh Kumar Singh. After going through the case file and deliberation of NEC committee noting number so-and-so dated 27/12/2001, committee has made the following observation. Date of birth recorded on late Paramanand Singh in service book in the soft Amalesh scheme was registered as 1/1/85. Late Panchananda Singh submitted PS3 on 17/3/88, where date of birth of late Amalesh Singh is mentioned as 2 years as on 1/1/87. Date of birth recorded by late Panchananda Singh in his son Amalesh Singh mentioned in 27 years on 8/8/2018. As per matriculation certificate of Amalesh Kumar Singh, date of birth is 15/10/88. In view of the above, the committee constituted by NEC has not able to establish the genuineness of the identity of the dependent applicant. So there is no reason to make changes in the recommendation of the dated 4/9/2020, which did not recommend the offer of employment due to non-establishment of genuineness of the identity of the applicant. So solely on the ground that my matriculation certificate does not tally with the date of birth recorded in the service book of my father. That is the ground.
So the ground is that you have got 4 date of births.
No, 2 date of births.
No, 4.
The same thing, madam.
The one is 1/1/85.
that is-
1/1/1987.
That is 2 years. 2 years means it will be 1/1/85.
So, okay, 2 years yes on 1/1. Then 27 years. 8/2/2018.
That is also same thing, my lord. That is
1985.
2018, my lord. If you minus my lord, 2018, my lord. Basically, it is 1/1/85 and 5/15/10/88. Only on that draft, but my assumption before my lord, regarding the date of birth, who is the correct date of birth? Date of birth as per the matriculation certificate is recorded as a correct date of birth. And even if it doesn't tally with the service book, whether that can be the criteria for rejection. How can it be that be the ground for disputing my identity, man? Where my identity has already been clarified, had been already been corroborated by the officials, man, by the video as well as by the other colleagues of my father, man. That there is a separate sheet is there, personal identification, and they have to put signatures. Personally, I know this person. So all the documents clearly shows that I am the son of so and so, late permanent Singh. Simply, there is a true date of birth doesn't tally, cannot be the ground to this to show that they're genuine, that I'm not a son of so and so. So my identity cannot be disputed only on the ground that there is a wrong entry in the date of birth. So the grounds that is assigned by this committee, my lord, totally irrational, vague, my lord, is not a consideration, my lord, valid consideration. So because of the illegality, irrationality on the part of the authority, my lord, I was deprived from getting employment. There is a violation of Article 14 of the Constitution of India, my lord. There is sheer case of arbitrariness on the part of the authority. Illegally, they have deprived me only on technical ground, my lord. So my humble prayer before that it should be interfered with and my case will be considered. This is my submission.
Your Lordship, in this case, we are not disputing his identity. He may be the son of Sohan.
Huh?
He may be the son of Mr. Panchanan Singh. But the date of birth, the father cannot be wrong. And the date of birth shown is 2 years in 87. And before he was born, how can it be? Name recorded in the service book.
Page 71.
On a year when he was not born. Shown as 2 years. And can the father be there?
Welcome, myself.
Yes. No, I'm not getting you. I'm not getting you.
Your Worship, in the service book, particulars of the family are given by the employee. That is the late father of the petitioner. And he has shown specifically the name of his son as Amlesh Kumar Singh was shown as 2 years as on 187. If he was born on that date,
So the 2 years will be 1985.
85.
Oh.
But he has claimed, the petitioner has claimed that his date of birth is in 1988.
Hmm.
So if he was born in 88, how could his name be recorded in 87? Why his father, none other than his father? Father must have known that he had given birth to a child. And service book he has given the details. At page 71 is it? We all sympathy for him from a local office here. They tried to give him the job, but the headquarters in Calcutta didn't take it. This is definitely doubtful. If that be the case, Lordship, and otherwise also, this is a compact case of compassionate appointment.
It's not a matter of right. There's no fundamental right involved in this. No violation of Article 14 of Supreme Court has held. In a matter of compassionate appointment, there's no question of any right.
Okay, I'll hear you some other day. Heard Mr. Good counsel. Also heard, Mr. MD Damat, the senior counsel, assisted by
AM
AM Datta. Datta. Then counsel, 40 respondents. All the respondents?
Yes.
40 respondents. Is the matter again on? When do you want?
Subject to your lordship convenience. Let it be pardoned by your lordship, heard the matter.
On 7th May.
7th, pardon.
What?
Election. Election is there, my lord. Local only there.
9.
9.
Can it be 14? 14, 15.
14.
14 is not ahead. Okay. Okay. 14.
Thank you.
Nineteen.
May I please, Lordship, letter maybe take up after 1 week.
You're for petitioner.
Petition,
Your good name?
M. Bora,
M. Bora.
on behalf of D. Borgohan.
D. Borgohan. On request made on behalf of MS D. Borgohan and the council. Please after 1 week.
1 week. Obliged.
20.
In item number 20, we has filed a new affidavit.
After fixing the matter for hearing lodged,
We has filed an affidavit.
without the leave of the court lordship, I have refused to accept this copy lordship, if lordship can permit.
Lordship, in court order 8 January 2024,
Also very voluminous.
We'll accept.
Lordship, there it was mentioned that before 29th of February, respondent number 4, 5, and 6 was supposed to be filed their affidavit, but they did not file their affidavit. And the last appearance also, I informed this honorable court that I've been preparing a document and I will submit before the date. Actually, I already informed this honorable court before submitting this affidavit. And this is not the first time the respondent number 4, 5, and 6 are creating issue. Lordship, after receiving the service notice, respondent number 4, 5, and 6 were not appearing this honorable court for a period of 7 months. And they directly delayed the process of.
Okay, 4, 5, and 6 were supposed to file affidavit by 29/1/2024.
29, yes, Lord.
He has replied to already.
And you filed your reply.
No, that is why I.
7th of February, Lord.
What is it?
7th of February, Lord.
They have already filed their affidavit. And he has filed it affidavit in opposition.
Lordship, they are misgetting.
in
Actually,
reply.
they were supposed to file on before 29, so that I can file my counter affidavit before 7th of February. But they did not file on 29. That is why I have to submit in a later period. They did not submit on time, Lordship.
So when did you file your affidavit?
7th of February, Lord.
7th of February.
Lord.
After that, you filed your reply.
I'm sorry.
He has already filed his reply. Then on 19th of April, he has filed another affidavit.
Another additional affidavit?
Yes,
Yes.
Lordship. Because they did not file their affidavit on time. That is why I did not get time, Lordship. I said on 7th of,
They filed a reply, they filed your affidavit on 7/2/2024.
yes, yes.
After that, you filed your reply or not?
On 7th, all on 7th only I filed because this honorable court, lordship, this honorable court,
When they filed your affidavit in opposition on 7/2, how will you file your reply on 7/2?
I did not file against the if reply in affidavit filed by respondent number 4, 5, and 6. I could not file because they did not file on 29. That is why I could not file. I somehow filed because this, as per this court order, the final hearing has to be done on 13. So anyhow, I have submitted 11 pages document. That is why I could not submit. And the last appearance also, I informed this honorable court that since I did not get time, therefore I have been preparing a document. So I will submit it before the next date.
The fact is, on 13/2/2024, you were heard in person. And submission was made that pleadings are complete.
Lordship, I have.
Accordingly, this court issued rule.
I informed this honorable court that I did not get time, actually. That day I already informed that I did not get time. I have verbally informed that this honorable court. The learned counsel said that pleadings are completed, but I informed this honorable court. And last appearance also, I informed this honorable court that since I did not get time, therefore I am preparing a document. I will submit it before the next date. Last appearance also, I informed this honorable court, lordship.
I don't remember.
Nothing is reflected in the order.
Yes, sir.
Nothing is
Not reflected, but I informed.
Now, let us come to one thing. Counter was filed on 7/2, correct?
Yes.
Correct?
Yes.
Did you file your reply or not?
Lordship,
I'm asking you one question, answer that question straight.
Yes.
Did you file reply to the counter affidavit?
I filed a reply, if it was filed, but since I did not get time, that is why I could not file.
Doesn't matter whether you get time or not. Have you filed your reply to the counter filed by the respondent?
4, 5, and 6, I filed a reply, lordship.
When did you file it?
It's on 12 of February, lordship.
Okay. So you filed reply.
Yes, lordship.
Where the counters? This you read petition.
The recent affidavit filed by the petitioner.
Affidavit in opposition. Respondents 2 and 3. Four, 5, and 6. 7 February. Where's your reply?
On 9th of February, lordship.
You filed on 9th of February.
Actually, they were supposed to file on 29th of January.
That is fine.
Yes, yes,
That
sir.
is fine.
That is why, sir, lordship, this discrepancy has been occurred, lordship.
No. They filed the affidavit in reply on 7th. You filed your reply on 9th, correct?
Yes, lordship.
All right.
Yes, lordship.
Then what happened?
Since I did not get time, that is why I informed this honorable court on
No, if
30.
you didn't get time, how did you file your reply on 9th?
That is what partly reply, lordship. One day, how can I reply, lordship, within one day?
You could have taken time.
Yes, that is why in the next appearance, I informed this honorable court that I did not get sufficient time. But the learned counsel informed this honorable court that already documents were filed, lordship.
Then what happened?
And also, lordship, in in 8 January 2024 without filing counter affidavit from my side. The learned counsel wrongly mentioned this honorable court that I have already filed the counter affidavit, but I did not file the counter affidavit. The learned counsel wrongly mentioned this honorable court. That is why this discrepancy has been occurred, Lordship, continuously. Since I am very much new to this honorable court, I did not know, but they are already misguiding this honorable court.
Serious
submitting-
allegation, my lord. That's a serious allegation, my lord. He should refrain himself. He should know the decorum of the court, my lord.
Are you a practicing counsel?
No, my lord, he is the petitioner in person, my lord.
No, are you a practicing counsel?
No, not Lordship.
You're a petitioner in person only.
Yes.
So what is this affidavit that you filed on? When did you file the
On
affidavit?
19/4, my lord, he has filed a 100-page affidavit, my lord. Copy is
19
not served to him.
No, actually, I request him,
Just a
but
minute,
he,
you have got your chance, please.
no, this is a new point, Lordship.
Now
I
the
request him that
situation
they
is that,
refuse
my
to
lord,
accept it.
after your lordships has passed the last order that pleadings are complete, fix the matter for hearing. After that, he wants to file another affidavit at present situation, my lord, on 19/4. Now, I have refused because I am of the view, I may be wrong, my lord. I am of the view that once your lordships has recorded that the pleadings are complete, there is no scope for any further pleadings in the matter. We'll go for the hearing, my lord. So that's why I refused to receive that, my lord. If I am wrong, then I stand corrected. I'll get the copy from him. But the fact remains that this will become a never-ending process if we go like this, my lord. We'll never reach to the hearing. So far as our affidavit is concerned, we have already filed on 7. He has filed his reply on 9. Why he filed so early, my lord? He could have, if he has got so many things to say, he could have taken a 2 weeks time or 1 week time. There is no urgency or no hurry. We never showed any hurry before your lordship, my lord. He could have taken 1 week more time, include everything.
But
I cannot make a submission that he is barred or whatever. If he wants to file, he can file it. It's absolutely discretion of your lordships, my lord. If your lordships permit, he can file it, my lord. It's not a big deal because we can amend the writ petition at the stage of hearing also, my lord. So that's why I refuse to receive, my lord, subject to what your lordships feel.
Where's your affidavit? You have not been able to file it.
No, she already filed, Lordship.
He filed, but I haven't received copy. My friend has received copy. If my lord permits, my lord, I'll get the copy from him.
The file is here, affidavit is here,
It's dated 19/4, my lord.
19.
4. Starts with page number 1451, my lord, at the top.
Last one. Last one, last. তলৰ একদম তলৰ খন। একদম তলৰ কপিটো।
Here, you have not mentioned anything, you're just filing affidavits. You're not saying reply to so-and-so, filed by so-and-so, nothing is there. You're just filing affidavits.
Lordship, because I did not get required document on time.
No, your affidavits, so many affidavits are there. Now, we don't know which affidavit is
Lordship,
against which counter.
no, I have already mentioned, Lordship, earlier one, since I did not get on 29.
I'm not on that. I'm on the way you're filing your affidavit. See, this is also an affidavit. No, this is an affidavit against whom? Against whom?
Lordship, in addition to, I have mentioned it in addition to my last affidavit on 12.
Where have you mentioned?
Top, my lord.
It says in addition to my writ petition and all my subsequent affidavits.
Last, yes, Lordship.
What does it mean? If you don't know the procedure of this court, at least try to take the help of the legal counsels.
He refused, my lord. But he refused, my lord. In fact, it was offered, which is recorded in the last.
Yes, Lordship,
Honorable Justice
Legal-
asked offered.
High Court Legal Service Authority is also there.
Lordship, I have taken the service for a period of 1 year. Lordship, but that did not, I have faced lots of inconvenience. I have.
So you think you are better than them, correct?
Not.
And that's why you file this type of affidavits, which I'm sure there will be nothing inside this. Anyway, you accept this affidavit, let us proceed with the hearing. Then maybe you'll have to reply.
My lord, we may have to. my lord.
They have to reply then.
That was filed on behalf of their reply only, Lordship.
Where have you stated that? Where have you stated that? Have you stated that?
Yes, Lordship, I have stated that they have submitted.
At least, where is it? Where is it?
Yes, Lordship.
Let us see. Maybe I'm wrong.
Lordship, page 1454.
1, 4. Five, 4. Yes.
The respondent did not follow the required order and instruction of this honorable court even after 10 months of time to respond against my submitted
Who is
petition.
this? Para?
Last paragraph, Lordship, 1454.
Paragraph is not numbered, my lord. Referring to the last paragraph
Which last para?
of 1454, my lord.
No, 1454, I'm somewhere in the middle now.
Now, my lord, he is, I think, referring to the portion at the bottom. 1454 at the top, my lord.
Page
1454 is this.
At the bottom, the respondents did not follow.
Here it says, it's in Roman 11.
No, my lord, then it's something different.
Therefore, in reference contrary to the details mentioned above in point 4.
Something is wrong.
1454.
Pagination may be wrong.
How many pages after the first page?
Fourth.
Huh?
Fourth page.
Even after 10 months of time, this one?
Yes, my lord.
Yeah. See, the last line, this is what you have stated. Therefore, in addition to my all earlier affidavits, I kindly submit the below mentioned details for kind consideration. This is not a reply affidavit, this is another additional affidavit.
And it makes allegations, my lord. If you lordship turns to the next page. Paragraph starting with capital A, my lord. Capital A, my lord. Just the next page. Against the unspecific, random and manipulated. So I have to reply to this one. Manipulated and contradictory statement by the respondents, my lord. Which respondent it does not specify.
Lordship, when I reply to respondent number 1, 2, and 4, 4 and 5, 6, everywhere I mentioned that the response are random, manipulated, and contradictory. Everywhere I mentioned, Lordship. And here I already given details where they manipulated the statement, where they given random statement. I have already just mentioned the details, Lordship. For better clarification of this honorable court, Lordship.
Okay, we'll permit him to file this affidavit. Now it's too late.
Absolutely. Let him have the satisfaction of, my lord.
Filing the affidavit.
After this, you cannot file any affidavits without the permission of this court.
May I make a prayer, ma'am? Lordship will grant us the liberty that if the need arises, my lord, we may file a reply to this.
Heard Mr. Abhinav Vora, petitioner in person. The petitioner in person has filed another affidavit on
1941.
on 19/4/2024. After rule was issued on 13/2/22. Stop. However, in the interest of justice, the affidavit is placed on record. You take your.
Yes, I have a copy.
Learned counsel for the respondents are permitted to file reply if so advised. Within a period of
3 weeks, my lord.
3 weeks. Now, list the matter after 3 weeks.
You'll furnish a copy of the same.
You finish a copy now,
Yes, sir, sure.
now they will accept your.
Oblige.
Obliged. Because I'm appealing for respondent number 4, 5, and 6. Respondent number 4.
We'll give the names, my lord. I'm appealing for 2 and 3. Give the names.
The last case. Huh? Yeah.
May I please, your lordship?
Yes.
Your lordship, I'm troubling your lordship, as regards item number 23, your lordship. The petitioner is undergoing dialysis, your lordship. There's an urgency. I pray that this matter may be taken up on 30th of April, your lordship.
Okay. Your good name, please.
D.S. Dekka, your lordship.
On request made by D.S. Dekka, the council deputies. Please down 30.
Yes, your lordship.
30 April.
Much obliged, your lordship.
May I please, the worship? Worship, same prayer, item number 21, matter kindly be fixed on 30th of April, madam.
Why?
Because petitioner has been discharged from the service and my lord, he is in depression, so matter may be kind of hard urgently, my lord.
Yes.
Subject to.
Yes, your lordship, please, my lord. I have no objection.
Okay, on request made by Mr.
Yes, Silas.
Then the council. Please down. Second.
My name may be also recorded.
Mr.
UK Goswami for.
UK Goswami, let us see a place for the response.
Hello.
Obliged.
I beg to mention item number 22, my lord, supplementary.
Yes.
Matter may be fixed on 14th of May, my lord.
On request made by Tia Patkari, then the council. So. 14th.
My lord.
14th.
My lord.